maybe my lord, how they are agreed, my lord. Now, my lord, the hostel construction, then my lord, then stop construction of hostels, then the quarters are going on, my lord, and they want to stop that developmental activities, my lord. I don't know what personal, my lord, problem they have. Suppose if there is
a personal problem, it's a
Mal-
PIL.
suppose
They have expressed their concern because forest land, according to them, forest lands
my
are
lord,
being utilized without following the due process of law. That is their concern.
my lord. Now, if that be only the sole ground, my lord, then my lord, we have to come up with a detailed affidavit, how the things started, my lord. Then, my lord, the NIT, they have to come up with the detailed affidavits. How, my lord, so far I know, my lord, that area was originally allotted to Government of Arunachal Pradesh Industrial Department, my lord. So that was, my lord, with mutual understanding. Then that was reallocated to NIT, my lord.
Mr. Nabam, this matter was initially filed as a writ petition, which was subsequently
Converted.
into a PIL.
Yes, my lord.
We can issue notice, you file your response.
Very well, my lord.
And madam, you need to place before us more particulars if you want the matter to be adjudicated in a proper manner. This may not be enough.
Yes, sir.
9 is connected.
9 is, yes, my lord, connected, my lord.
Construction of the NIT.
My lord, same issue, my lord, that no NOC has been obtained, my lord. Interconnected.
In 9, this notice has been issued.
Yes, my lord.
You have filed your
My lord, affidavit we have filed in 9, my lord.
will your affidavit in 9 cover this case also?
My lord. My lord, this was filed by the Deputy Commissioner. My lord, I wish that the guardian of the land, that Secretary Land, when my lord, he should file my affidavit.
Okay.
Since this was almost sort of policy decision, my lord. So so, my lord, 1 and 9 may be clapped together, my lord.
But notice has not been issued, is it? Has it been issued?
No, this is coming for the first time, my lord.
(1811) order. 1811 order. What's your name? 1811. Order is 1811. Yes, sir. Motives of the activity. After it, right to the official has been given on the next page. This turnover page.
My lord, one more just information. Now, my lord, this NIT, they have their own standing council since they being an autonomous body, my lord. So notice has to be issued to them also.
Yes, yes. Okay. Oh. What is your name?
Your Honor, Vai Singhi. Oh, yeah, Anup Singh.
1, 2, 3, 4,
Y.
5.
Singhi.
Yes, Your Honor.
Miss Y. Singhi, learned counsel for the petitioner. Full stop. Though initially this petition was filed when the matter was taken up for consideration on 28/8/2025, a learned single judge, after considering the subject matter involved, which appeared to be directly connected with the public interest, had directed for registering the case as a PIL. Subsequently, the matter had come up for consideration before this court. Full stop. The matter is with regard to certain allocation of land to the campus of the NIT in the state of Arunachal Pradesh. Full stop. It is the case of the petitioner that the said land measuring about 302 acres is forest land in the Papum Reserve Forest, and no clearance or NOC has been taken in accordance with law. Full stop. We have also noticed that when the matter had come up for consideration on 2/9/2025, an objection was raised by Sri R.H. Nabam, learned Additional Advocate General, that there is no compliance of the Guwahati High Court within bracket PIL bracket close rules 2011. Full stop. Para. Be that as it may. Considering, no, he has also submitted that the NIT is a premier institute and all activities have been carried out in accordance with law. Full stop. Para. Be that as it may. Taking into consideration the subject matter involved, let notice be issued, returnable by 4 weeks. You'll, Kato,
What's the respondent number?
one and
I
Only
put
one.
2.
M. Kato, Deputy SDI for 1, Sri Arichanam AG for 2.
2, my lord.
Why have we made these persons parties by name? Where is the NIT?
Yes, Your Honor.
NIT is an institute, my lord. National Institute of Technology, my lord. It's not that NIT like
No,
contract.
where is the NIT? The respondent?
Honor.
NIT.
Yes.
They have not met the party. But in 9, they are party.
Think
You have not met party.
Don't write the last part. Madam, this is not how you present a petition in the High Court. The legal entity is not before us. Who will respond? And why have we made these officers parties by name? Is there any malafide in you're alleging?
no, Your Honor.
Then,
Oh, by name.
Your Honor.
after Nabam's, after Nabam's, a perusal of the cost title would also show that the NIT has not been made a party respondent. Full stop. Considering the above, before consider in view of the above, before considering as to whether notice can be issued or not, but the petitioner is required to file amended cost title along with other particulars which are required to present a PIL in accordance with the rules mentioned above. Such list after such additional affidavit, including amended cost title, is filed by the petitioner.
My lord. Of like, my lord.
Dear Knowledge. Item number 2.
Item number
May it
2.
please your lordship. May it please your lordship.
Yes,
Am I audible to your
yes, very audible. You are audible, but you are not visible. Now you are visible also. Yes.
Now, my lord, this petition has been necessitated in view of the situation that has arisen in Arunachal Pradesh, more particularly in Itanagar, because of the ensuing elections of the All Arunachal Pradesh Students' Union. Now, my lord, your lordship may be aware, this has been reported in the Arunachal Times from 1st of February onwards every day, and also in different channels, my lord, the situation, the mayhem that has been created. My lord, may I take your lordship directly to the to show the what has happened at to page 84 of the petition, my lord. Some photographs I'd like to, my lord, bring to your lordship's notice. Page
But
84,
election
your
matter,
lordship
can
will.
we intervene?
My lord, yes, my
Election
lord,
matter-
the election matter, my lord, I have got two submissions in this regard. Firstly, my lord, although this is an election of the Students' Union, but then, my lord, it has, my lord, concerns a large number of students all over the, my lord, state of Arunachal Pradesh, then, my lord, Assam, West Bengal, and Meghalaya and Delhi. They are also, my lord, a part of the election process. So, my lord, a large number of people are involved in this matter. And secondly, my lord, there is a report of the Lingdo Commission constituted pursuant to the direction of the Honorable Supreme Court, which, my lord, gives some directions for implementation, and the, my lord, the Honorable Supreme Court has given that direction also, my lord. Though all those, my lord, recommendations have been given a complete go by, and, my lord, election has been sought to be, my lord, held in a, my lord, very high-handed manner to benefit some persons, my lord. It is no longer, my lord, a students' union simpliciter election, my lord.
When is
The
the
large
election?
number of, my lord,
When is the election? When is the
election
election?
notification has been issued, my lord. If your lordship turns to page 87, your lordship will find the election notification dated 5/2/2026.
When is it
And
scheduled?
the 17th, my
When is
lord.
it?
17th
When is the
issue
date?
nomination paper. My lord, ultimately the voting process will be, my lord, on 22nd of February. But
We
then, my
cannot
lord,
stall
what
the
happened,
elections.
my lord? My lord?
We cannot stall the elections.
My lord, your lordship will
It,
kindly bear with me for a while, my lord.
Election stalling
Now-
will have a wide ramification. We cannot,
my
unless you
lord.
make out a gross case of
That is
illegality.
what I am, my lord, trying to satisfy
We
your
can,
lordship, my
we
lord.
can ask Mr. Nabam to have the instructions and have this matter on Monday. Monday is what?
Monday, 16th.
16th.
My lord, what happens? The
Yes.
entire election process starts with registration, my lord, and that has to be notified with,
Mr.
my lord,
Nabam?
by
My lord.
15 days.
We are
That
not,
notification never
we are
came.
not in favor of installing the process of elections.
Right, my lord.
It's involved, and once it gets stalled, Monday we can have it. We have the instructions.
My lord,
My lord.
There, yes.
what
Mr.
we
Chaudhary.
wanted in this petition is that, my lord, the Supreme Court directives should be implemented, and, my lord, here the process of election started without a notification regarding registration, and there, my lord, these gunshots have been, my lord, have been fired, and two groups
No,
are, my lord,
Mr.
clashing.
Chaudhary, Mr.
FIRs have
Chaudhary,
been
we have
registered.
seen your petition. We are not averse to issuing notice at this stage, but so far as your prayer for interim order is concerned, that we are not inclined.
Monday,
So
exactly.
we
We're not
think that Monday it can be considered along with certain instructions that can be obtained by Mr. Nabam.
My lord, any specific instruction, my lord?
Now, on this, regarding the for implementation of the recommendation of the
Lingdo committee. my
Lingdo
lord.
committee.
My lord.
What I am, my lord,
Lingdo-
on is that
And
if the process
what
goes
steps,
on, my lord, there may be
what steps have the administration taken
My lord.
to towards the issue
Any sort
of
of-
violence and
My
all
lord.
those? On that, Monday we can have.
Monday,
it.
my lord.
Monday.
Then,
And
my
the
lord,
prayer,
may
Mr. Bharadwaj, committee report, what committee report? GM committee report?
Lindo committee report.
Huh?
The Lindo committee report.
What,
that I
how
have
do you write?
annexed.
It's
In paragraph, in the prayer 22,
Lingdo committee.
is it called GM committee? Huh?
Other
the Lindo.
It is GM committee.
The Lindo.
If you don't write Lingdo, GM will not have any meaning.
I'm sorry, madam, but it's annexed, madam. It's
That we have seen. If you had written Lingdo committee also, matter would have been, but JM committee, there is no JM committee as such. Okay, Monday we'll have Mr. Chaudhary.
My lord, your worship will kindly
MK
also
Chaudhary.
ask them to obtain instruction as to what happened on 30th, my lord.
Yes, I heard three MK Chaudhary and a senior counsel appearing online, who is assisted by Sri P. Bharadwaj for the petitioner. Full stop. The present petition has been filed in the nature of a PIL in connection with the elections of the what do you call Arunachal Pradesh?
All Arunachal Pradesh
Pradesh Students Union. Full stop.
my lord.
Specific allegation has been made that the recommendation of the JM Lingdo committee have not been followed And on 31/20/26, comma, a serious incident had taken place which would reflect that the process has not been conducted, not carried out, in accordance with law. Para? Let instructions be obtained by Sri R.H. Nabam, the learned AAG, Arunachal Pradesh. Let this matter be listed for consideration on 16th.
My lord, your lordship may kindly also ask them to obtain a, my lord, instruction as to what happened on 30th January.
Yeah, we
and, my
have
lord,
indicated 30th.
My-
We have indicated. Okay, yes.
And my lord, what is the steps that the authorities have taken, my lord?
That your lordship has said.
God bless
Okay.
you.
Item number 3. Your Honor, I'm for the petitioner. They were about to file affidavit in opposition.
Yes, what,
Here,
you
Madam,
fight or not?
No, my lord, not yet, my lord.
Matter of which year?
24, my lord.
24, we are taking, what is the matter about PL
They have challenged the notification, my lord, of
of,
12/5/2000.
what
Fine,
is it,
madam.
what is it about?
It's
To create in special investigation cell
in each district, my lord.
in each district for officer against corruption, to complain officers against corruption
There,
and any other.
against declaration. You are aggrieved by, or what? What is your prayer?
Your Honor,
What do you want?
My lord, their prayer is to create SIC cell in every district, my lord. But by this notification, my lord, 12/5/25, my lord, only in Itanagar, my lord. It's only in Itanagar, my lord.
Okay. Heard Miss so your name,
Vaisingi.
why single learned counsel for the petitioner, para? Miss Wangmu, the learned state counsel, has renewed her prayer for grant of time to file the counter affidavit, para? We have, however, noticed that on a number of previous occasions, time was granted to the respondents to file their affidavit, para? In that view of the matter, to the authorities, and this PIL is pending since the year 2024, para? In that view of the matter, a final opportunity is granted to the respondents to file the affidavit in opposition. Full stop, list after 4 weeks.
Yes, ma'am. Obliged, ma'am.
Obliged.
Madam will not grant further time.
Item number 4.
May I please, my lord? My lord, by last order, my lord, 12/11/2025, my lord. I'm sorry to say, my lord, I was directed to file an affidavit showing the, my lord, current vacancy position of the work charge employees, my lord.
Yes.
My lord, I could not file the affidavit, my lord, so I seek, my lord, further time, my lord, to file that affidavit.
How much time do you need?
2 weeks, my lord.
My lord, otherwise everything is in the record, my lord. We can dispose of the matter based on the record, my lord. My lord, challenge the writ petition was it, my lord?
No, there's an order of 12/11. Let him comply with the order. Heard Sri R. Saikya, learned counsel for the appellant. Also heard Sri D. Kamrup, learned counsel for the,
Respondents.
who, you are for department.
No, my lord.
I am for the department, my
He's
lord.
for the department.
This is a repeat, or for the respondent writ petitioner.
Yes, my lord.
Sarah? But you are directed to file an appropriate application,
My-
not an affidavit.
No, first paragraph, my lord, affidavit, my lord.
Okay. wide the last order dated 12/11/2025, time was granted to the appellant to file an affidavit to bring on record the number of posts POSTS in the cadre of WC Khalasi and also showing the man in position. Sri Saikya, the learned council has submitted has prayed for some more time to file such affidavit. 2 weeks
2 weeks, my lord.
in view of the above. 2 weeks time is granted to enable filing of such affidavit.
Okay, my lord.
My lord, in the
Could you fix a date, Mr. Kamduk, if you're
My lord.
Date?
My lord.
no, my lord, after 2 weeks, my lord, we'll make the mention, my lord. Only the, my lord, the thing is that, my
have
lord,
you filed your application?
no, my lord.
You're also supposed to file an
My lord, I do not, I haven't received any instruction, my lord. That's why, my lord.
Okay.
Item number 5.
Then so put on the AC is on. AC is on. AC is on. Please on. Switch it. Really warm it, no? Item number
5, ma'am.
5. Yes, what is it?
Oh, my lord, I was supposed to mention in the morning, my lord. But I could not. My lord, my leading counsel is out of station, so the matter will be fixed on
Who is out of station? Lolen.
Elon, man.
Yes, madam. It is.
Lordship, I was directed to bring the status report of the
Current
current
status
status.
of the allotted land.
Yes,
Yes, you have got the,
yes, Lordship, very. I have received it.
your land has been given to Karate Association and
Yes.
BJP office
Yes, my lord.
without your knowledge.
Yes, my lord.
Yes, madam.
Lordship, regarding that, Lordship, I was supposed to take instruction. I have taken already, Lordship. I have received the instruction.
Okay, a prayer for adjournment has been made on behalf of Sri K. Lolen, Learned Counsel for the appellant. Ms. G. Ete, Learned State Council has however submitted that in terms of the earlier order, instructions have been received with regard to the current status.
Yes.
Be that as it may. Matter is adjourned by 2 weeks.
My lord, maybe on 19, my lord.
On
19.
19.
Yes.
Matter is adjourned to be listed on 19th. Are you okay, madam?
Lordship, I have.
No, don't say, be that as it may, and on, be that as it may, as requested by the Learned Counsel for, requested on behalf of the petition, appellant, list on 19th. Okay, this you can present on the next day.
Okay, my lord.
Item number 7.
Why is it for orders, Mr. Mao?
Yes, your lordship. Well, last order, 3/11/2025.
As per number 4, affidavit is there on records.
Respondent 4.
4 has filed on 28th
Yes.
and 2025.
Oh, yes, the.
Yes.
Settlement
What
Commission.
is this matter about?
Well, this matter is related to functioning of State Human Rights Commission. As of now, only one member is appointed, and they are yet to appoint chairman and one member from the judicial background. So they have advertised in the state portal on, and then they have given last date is 24/5/2024. But then that was not published in the state newspaper. It was in the state portal. So maybe that could be a reason no applicant has come up for this 2 posts, which is yet to be advertised.
You're for?
Lordship, I am for respondent number 4.
Who's for?
4 is the Secretariat of
State-
Human Rights.
Okay, what steps are you taking?
Your Lordship, may I take you, your Lordship to
Now, are you taking steps for filling up the post of chairperson and member judicial?
Yes.
What steps?
Your lordship, one member has been, non-judicial member has been appointed.
That he has already said. What about the other two?
Other two, for that, your lordship, instruction has need to be taken.
22, we are in 2026, 4 years, you have not taken instructions or steps. This is not done. This is a creature of a statute. It cannot be only on papers that we have a human rights commission without functioning. Mr. AG,
My lord,
22, since 22 matter is pending and you have not taken any steps
the
to make it
last,
functional.
my lord. The sanction post, my lord, we have given, my lord, in
No,
our
you have to undertake a recruitment process. What Mr. Mao says in 2024 itself, he had given an advertisement in the portal for which perhaps nobody applied and you could not fill it up. But where is your endeavor thereafter to fill up the post and make it functional? One is not required to come to the court to make a human rights commission, get it functional.
My lord, initially, my lord, their approach was something different. But subsequently, my lord, they said, my lord, there is no creation of post. Then we have created. I think if I correctly remember, my lord, last time, my lord, advertisement was issued, my lord. Then, my lord,
No, if you see the prayers at page 14, prayers are very innocuous, only having a human rights commission functional.
my lord,
And this matter is pending since 2022.
my lord, so far function is concerned, my lord, function is on, my lord, but full-fledged, my lord, with
How can you
manpower, my lord, yes,
How
my
can
lord.
you function with a member without a chairman,
Yes.
without
Well,
a member judicial?
My chairman was there, my lord. Justice Indra Shah, my lord, she was appointed. After that,
When-
chairman, I
when
think-
did she demit office?
2025, if I correctly remember, 24 or 25.
My lord, in
Yeah,
fact,
no?
they have issued appointment order, but then that was without any office, any infrastructure, any staff. So maybe that earlier chairperson could not function because of that reason.
My lord,
This all infrastructure were created only after this coming of one member.
We cannot be oblivious or cannot keep our eyes shut. We are aware that even the Lokayukta is not having any facilities.
my lord.
These are part of the state, not only on papers, these are all statutes.
My lord,
Human Rights Commission doesn't have a proper office. Lokayukta does not have the infrastructure.
my lord,
How does it function?
so for Human Rights Commission is concerned, my lord, they have an office, they have a block, my lord, they have a manpower.
Now they have. They have.
My lord, at least my friends agree, my lord. Maybe initially, my lord, maybe.
No,
my
Mr.
lord.
Abam,
Now, my
see,
age on
Mr.
that,
Mao, it's not an adversarial litigation.
my lord,
It's a public interest in the interest, sole interest is of the state,
my lord.
which has to follow the mandate of law. Law requires that there has to be a functional human rights commission.
Right, my lord.
Yes.
So for that infrastructure, all the chairman, member, the judicial have to be there.
Correct.
At one point of time, somebody may retire, he might take some time in inducting, but it cannot go on for 4 years.
My lord, chairman, so for chairman concerned, I think
Here,
Presently, we do not think there is any chairman in the Human Rights Commission.
2025. not
lordship,
before.
may I take your lordship to
Yes, what
My
is your name? We
affidavit.
did not get your name. Your name,
No, I mean,
K. Posi?
Posi.
Yes,
Mr. Posi, do you have a chairman now?
yes.
Chairman is
One
there.
judicial member has been appointed, but he is functioning as a chairperson.
But
No, no,
not
no,
a fully
Not
recruited.
full place, not
full-fledged,
full.
no.
Who's the member judicial?
Actually, your lordship, earlier, Honorable Dr.
Present कौन है?
Mrs. Justice Indra Shah was appointed.
Appointed.
No, she was the chairperson.
Yes,
Now,
he was chairperson.
who's the member judicial? Who is presently acting
Present.
as chairperson? Who?
He is non-judicial member. He is a Bamang Tagoy. And now he has been authorized to function as a chairperson.
Perhaps temporary padal hoga, he said.
But you need to make appointments, make it functional. Otherwise,
Yes.
it will be only on papers. When can you come back, Mr.
My lord,
Osim and Mr.
can it be after 1 week, my lord? Because I believe, my lord, advertisement was, my lord, published, my lord. Perhaps because there are some, my lord, some criteria there.
Third-
Age bar, all these
Third
things,
Priya
my lord.
Mount Learned Council for the
It's a normal last time, pa.
petition, the instant writ petition filed in the form of a PIL is with regard to the establishment of the Arunachal Pradesh State Human Rights Commission and to ensure its proper functioning in terms of the Act of 1993. Full stop, para. Now the Learned Council has submitted that as on today, there is no chairperson and member judicial. And the commission is functioning only through a member, full stop, para. The requirement to have a functional Human Rights Commission is mandatory for each state under the act in question. Full stop. The state is obligated not only to ensure that the chairpersons and members are appointed but also to ensure that such commission is made functional by providing all necessary infrastructures, etc. Para. Both Sri Pusi, the Learned Council for the Respondent of Force, and Sri R.H. Nabam, the Learned AG, are directed to obtain specific instructions on the steps taken to make the commission functional from all sides. Para. List after 2 weeks.
Obliged.
Item number 8.
May it please your lordship. My lord, this is a jail appeal, my lord. Here, for respondent also, my lord, the legal aid council has been appointed. So this matter may be fixed, listed for hearing, my lord.
Other side,
Other side, senior advocate Muk Patin is there.
he is not there. None appears for the appellant on call, whereas Sri K.A.T. Learned, your PP,
Additional PP, my lord.
APP. Arunachal Pradesh is present. He has also informed that a legal aid council has been appointed
Yes,
for
ma'am.
the respondent number 2.
Yes, ma'am.
Para. Since the paper book is prepared, list this appeal for hearing in its
Yes.
in its turn,
Yes.
on its turn.
Yes, ma'am. Deeply obliged.
Item number 9.
My lord, this item number 9 is connected with item number 1, my lord.
Yes.
Yes.
9 who is appearing?
Same council, my lord.
Madam?
Madam, I think she left, my lord, madam.
We'll say, will not record her absence, we'll say list along with her.
My lord.
This court has been informed that another writ petition has been filed on the issue being which was on this issue, which was subsequently converted into PIL number 14 of 2025, correct?
Yes, ma'am.
List along with PIL 14 of 2025, which incidentally was listed, which incidentally has been listed today. Full stop. List along with PIL 14 of 2025.
Item number 10.
Item 10 PIL. By their affidavit.
My lord, yes, my lord, we have filed the affidavit. my lord.
What is the matter about?
My lord, the allegation is overlapping of the road, my lord. Then we have said, my lord, in our affidavit, my lord, the
Okay, the none appears for the petitioner on call, whereas Sri R.H. Nabam, learned AAG is present for the state para. Office notes would indicate that neither ready card nor unserved notice has been received back in respect of the respond numbers 5, 6, and 7. Full stop. Let this matter be adjourned by a week, when this court may pass further orders for taking fresh steps on the aforesaid respondents 5, 6, and 7.
Well.
So G. Tarak, learned tenant council, RD, RWD is present.
Item number 11.
PL,
Yes, my lord, I had received a additional affidavit filed by the respondent number 4, 5, and 7 plus 6, my lord.
yes,
So I need some time to go through, my lord.
okay. The respondent numbers 4, TO26 have filed an additional affidavit on 6/2/2026.
Yes, that's
Full stop. The learned counsel for the petitioner has prayed for some time to enable him to obtain instructions and oblique or to file response to the same. List after 3 weeks.
My lord.
Ms. G. Ate, learned state counsel, G. Bam for respond number 7. And your name is T. Gado for respond number 8 are present. T. Gadi.
item number 12. May I please, your lordship?
Yes, please.
By the order dated 21/10/25, TCR was called for, but the office note says it is not come.
It pertains to
This is
Under
a
what?
conviction under 302 Arms Act and also for causing disappearance under
okay, this registry will call for the get it this year.
TCR was already called for on 21/10.
Understood. Registry will get it this year.
Yes,
Okay. We'll give a reminder to the registry.
yes,
You are appearing as what, Mr.
as legal aid counsel,
Heard, Ms.
appeal for appealant.
Learned legal aid counsel for the appellant. Also heard. Who's there? Ete is there? Kete? Where is it? Where are you? Also heard Sri K. learned.
Miss Jeannie was appearing last time. Miss Jeannie had appeared.
Any colleague of hers? But Ete was there. Kento Ete was there. Also heard Sri K.
Token.
learned.
Theatre also.
T8, sorry. Token at T8 learned additional PP. Para. Do TCR where TCR and small s, TCRS were called for. Office note dated 11/2/2026 reflects that the same have not been received. Para. Registry is directed to give immediate requisition for immediate reminder for requisition in the same. Para list after receipt of the TCR,
All right,
whereafter appropriate orders for preparation of the paper book would be passed.
all right.
Item number 13.
My lord, this is jail appeal. I'm for the appellant as a legal aid counsel.
Okay, with similar power will pass a similar order.
Yes.
TCR not received.
Yes, ma'am.
Okay, heard. You're a legal aid counsel.
Yes,
You're
madam.
Jayadoji
Yes, my lord.
instead of Nikita Duncan, you read Jayadoji, huh? And office note dated 11/2/2026. Arrest all same, huh? Office to give reminder.
All right.
Item number 14.
PIL,
My lord, as per last order, my lord, I have obtained the instruction, my lord, from the Anti-Corruption Bureau, my lord. My lord, they have obtained my approval. Now, approval inquiry is going on, my lord. Now, since this is allegation, my lord, construction of road, my lord, sub-eastern, all these things, and this ACB, my lord, Anti-Corruption Bureau, my lord, they are not technical that experts. So what they have done, they have requested Constant Deputy Commissioner to constitute a technical, my lord, board, and they will submit to this, my lord, investigation agency, my lord. Then they will conclude the inquiry, my lord. That is what the status
But
report.
you are required to take steps for 226. You have not taken steps.
Yes.
You
Ah.
take steps.
Yes.
What is your name?
BCBO.
Office note dated 11/2/2026 reflects that steps for service of notice upon the responsibles 2 TO2 6226 have not been taken. Para? Sri D,
BCBO.
where your name is not there.
And there are third roles.
Acha, BC book, learned counsel for the petitioners. Pray for undertakes to take steps, full stop. Let such steps be taken within a period of 3 working days. Full stop. The matter be be listed after 4 weeks along with service report. 3 RH Nabab, learned AG is present, who has submitted that instructions have also been received.
My lord.
Item number 15.
15 years. Who's for 15? Dusurilu.
Yes, Lordship.
I for
IA is for implementing the new parties.
implementing or
Yes.
implementing.
Impleading.
Implementing
Not
for
implement-
new
You
parties.
cannot implement a party.
Yes.
You have to implement a party. Notice, whom do you want to implement?
Lordship, in here, respondent 15 is copy is not served. It came unserved. So I'd like to pray for some more time to take a fresh step upon the respondent number 15.
Just
May I please, Your Lordship?
yes. You're for whom?
I'm appearing for opposite party number 14 and 15. We have
Okay.
some objection, so we need to file an affidavit and please grant some
Objection
time.
regarding what? Objection regarding?
Objection regarding the implement, Your Lordship.
6.
Just a minute.
6.
6 and 7.
6 and 7. As petitioning. Sir, 6 and 7 is this.
No. How can she raise objection for that?
This is not particular.
Who are we how?
Get little certificate whether it has connected with the party. And then we can notice. Before we
6 and 7 implement के लिए वो क्यों objection कर रहे हैं? आर्मी तो वहाँ बैठा हुआ है.
Yeah, the site is also will kind of
drafting book ulta.
Yes, madam, since they'd like to file the objection, that they have already entered appearance subsequent to the notice issued by you, steps taken by you.
Yes, yes. Yes.
Your name is Durilung.
Dirilong.
Uh-huh.
Yes, Dusurilong.
Heard Miss D. Rilung, learned counsel for the applicants oblique petitioner. Full stop. In this IA, notice was issued on 18/11/2025. Full stop. Para. Miss, yes, madam, what is your name?
Ms. A. Roy.
Ms.
On
A. Roy,
behalf-
Leonard Council appearing for the spot
On
numbers
behalf
14 and
of
15.
S.
Behalf
On
of?
behalf of S. Sahu.
Okay, doesn't matter. You are on record. Ms. A. Roy, Leonard Council appearing on behalf of the spot numbers 14 and 15 online has submitted that objections would be filed in the IA. Full stop. In the IA for which she prays for 2 weeks time, madam.
Yes,
Two
Chairman.
2 weeks time. Let objections be filed and the matter be listed after 2 weeks.
Item number 16.
Hey, please, my lord. My lord, on the last occasion, this formal court has directed to file an IA to amend the course title, my lord. So we had filed the IA
IA for?
for amending the course title, for replacing the respondent number 5, my lord.
We'll allow this. We'll allow this. Huh? Item number. What is your name? Amratan?
M. Ratan, my lord.
Third Sri Amratan, Leonard Counsel for the applicant. Applicants plus appellant. Applicants as plus appellants who has filed this application praying for amendment of the cost title. Full stop. It has been submitted that the spot number 5 was earlier described as follows. Come down. Come to paragraph 2 of the IA, page 5. NHPC Limited through CMD, Faridabad, Haryana. Full stop. However, the description should have been as follows. Executive Engineer, Dibang Multipurpose, National Hydropower Corporation Limited, Lower Dibang Valley District, Roing, Arunachal Pradesh. You see from paragraph 5, paragraph 2. Okay, separate. Para. Also had Sri R.H. Rama, the learned AAG, who does not have, who does not have objection to the said amendment prayed for. Para. After considering the facts and circumstances, the instant I is allowed, and the respondent of 5 and the description of the respondent of 5, as mentioned above, is allowed to be amended. Full stop. The I stands allowed. Para. The learned counsel for the petitioner, for the applicant, is required to file amended cost title in the connected PIL. PIL.
No, read
the
the
connected
bill. My lord, we will take steps upon the respondent number 5.
First, you have to amend the cost title, then we'll.
Okay.
And since it is an HP, I think the same counsel will be appearing.
My lord, Mr. Tiwari, I think.
And this is an appeal, continuation of the proceeding.
Yes.
So there may not be a requirement to take further steps.
Matter is finished.
Okay, in 5 minutes, we'll come.
Please, Your Lordship.
Yes.
Well, one matter which has been listed last on 22nd of January 2026. It was for 2 weeks. It's a land compensation. So can it be taken up on 25th, my lord? It is on Wednesday. Because that's
the other side?
Other side, it has been informed. No, it has been by phone. Then also WhatsApp also, it has been informed, notified to the other side.
25th.
25th is a Wednesday, my lord.
Number of the case. Okay.
Yes.
3. This is mentioned number. Okay.
No, we have given a mention memo also, my lord.
On 25th.
Yes.
25th, my lord, and it is can come on admission column, my lord.
Okay. You've written admission.
Yeah, admission. He'll write admission
Okay.
column.
Okay.
There was some urgency, that's why I'm mentioning. Otherwise, I would not have mentioned.
Let us.
Because this is a beneficiary and that my money has been, it is lying. And somebody comes before this court who is not a person interested, files a reference before the learned reference court.
Okay, we'll see. We'll
Yes,
see.
ma'am.
Okay.
I'm deeply obliged, my lord.
Yes, Mr. Tungan,
Yeah. My lord, in today's item number 9 and 10, I have filed two IS.
bring it.
Yes, ma'am.
Are you for?
I had to bring on record the latest status of the land acquisition process.
That may come, my lord. I
That
have
may
been
be
served, my junior here has been served with notice yesterday, served with that copy also.
Okay.
That may come, my lord, while taking item number 8, 9, 10, right?
9, 10.
I have pleaded lordship, my lord. I beg to mention item number 19, my lord.
19.
Yes, my lord. Here, my lord, senior government advocate was appearing, my lord, as Tapin, my lord. But due to some personal problem, my lord, he's not able to come today, my lord.
Okay, Mr. Saikya has been informed.
I've taken consent, my lord.
When do you want? After a week?
Yes, my lord.
After, my lord.
Okay. Prayer for adjournment has been made on behalf of Sri S. Tapin, learned senior advocate, Arunachal Pradesh. Full stop. Sri R. Saikya, learned counsel for the petitioners, is present. Para, please after a week.
If it please your lordship, I beg to mention item number 7.
7.
Yes, your lordship.
Yes.
My lord, the leading counsel, Mr. Panging, is out of station, your lordship. Can this matter be fixed on 19th of this month?
19th.
Yes,
Okay.
sir.
Common counsel, madam, one more. Item 7.
Yes, lord.
Okay. On a request made on behalf of Sri Deep Panging, learned counsel for the petitioners, matter is adjourned to be listed on 19/2.
Much obliged.
Item number 1.
Yes, Mr. Deori, what is this?
This is a writ petition against the disqualification order issued by the Deputy Commissioner Hawaii. Disqualifying
Disqualification as what?
as Gram Panchayat member.
What are the grounds of challenge?
Ground of challenge is before issuing this disqualification order, I was not issued any notice or opportunity was provided to me. Place our side of the case without any information and our hearing us. And on top of that, we had marched with 2/3 majority, which is already intimated to the impugn order is in page 31. From the impugn order, it is clear that no notice, no opportunity was given. Based on the complaint only, they had taken actions against us.
How do you stay a disqualification order? How do you stay a disqualification order? You're praying for a stay also.
Yes,
How
Your
to
Honor,
stay?
because I can march as per the Panchayati defections rules. If 2/3 majority march, then
No,
disqualification.
not on the ground, not on the merits. But this disqualification was done on 6/2/2026.
6 to 26.
Now, after it has come into effect, it will amount to putting you back on that seat. You are not on that seat now. Where is the scope of interim?
Yes,
order?
I'm not in the seat, but opportunity had been before issuing
No, that-
such orders.
That we are issuing notice, will examine.
Yes,
You may be
Your-
successful in your final endeavor.
But the thing is that if I'm disqualified, then that particular segment will be remain unrepresented. And that's,
No, we may direct not to fill up that post till the returnable date.
but stay may be given till that.
Stay will mean reinstating you on the first date, which perhaps cannot be done. Do not fill up the post. Okay? Do not fill up the post immediately till the returnable date. And we are also issuing notice on your interim prayer. We'll consider, okay? Heard.
Your Lordship, if we see section 3 of the Panchayati Defection Law Act, Your Lordship.
Okay. I am, yes, I do. That book.
Item number?
No, book.
Book Panchayati Manual.
Yeah.
What is there, Mr. Iran?
Your Lordship, it's regarding disqualification on ground of
What is
defection.
there? Please.
Your Lordship, manual.
It's page 160.
165, Your Lordship.
You tell us what do you want to submit?
Your Lordship,
Are you having this book?
yes, Your Lordship.
Page
165, Your Lordship.
165.
Yes, Your Lordship.
That's it. Yes,
May I, Your Lordship? Subject to provision of section 4, 5, and 6, Your Lordship. And if Your Lordship may turn to page 168, Your Lordship.
Hmm.
This has been slightly amended, Your Lordship.
yes.
And section 4 has been omitted, Your
Omitted,
Lordship.
yeah,
Yes,
that
Your
will-
Lordship.
yes.
And the case of the prisoner is that, Your Lordship,
Section 5.
is regarding where member makes a claim that he and any, section 4, Your Lordship, if I
Yeah.
may.
No,
Yes.
5. I'm claiming section 5. Merger.
No, Your Lordship. Section 5 is where his political party merges with another political party, Your Lordship.
Yes, I have merged.
It's regard to political party, Your Lordship, not individual, Your Lordship. Here in the case, petitioner and two others, they themselves merged and formed a separate party, Your Lordship.
Okay.
There is
Part-
only one.
Sri D.K. Deuri, learned counsel for the petitioners. First of,
Yeah.
the petitioners who are 3 in numbers were elected as Gram Panchayat member,
Yes, Your
Member.
member from 11/2, 11/3 and 11/4 constituency segment of 11 Goiliang,
Goiliang.
the Gram Panchayat, full stop. The grievance of the petitioners is, so when was the election?
Election, this was Panchayat election was on 29th of December.
Such elections were held in December 2025.
Yes.
The grievance of the petitioners is with regard to an order dated 6/2/2026, whereby they have been disqualified. Full stop. It is submitted that apart from the aspect of not giving any opportunity or notice
Notice.
before such impugned order was passed, there is gross violation of the rules holding the field. Full stop, para. Sri Y. Ram Learned State Council has, however, submitted that the reliance upon the provisions of rule is fallacious and
Yes, Your Lordship.
the disqualification has been done in accordance
Yes, Your Lordship.
with law. Para. Be that as it may, let notice be issued, returnable on whichever date. Today is 12th. We'll have it on 2nd of March.
Yes, Your
You
Lordship.
have to bring the instruction. Okay.
2nd of March, it can be possible. It's 9th of March.
9th of March, 9th of March. Mr. Ram, you'll have there are private respondents also.
Yes, Your Lordship.
You'll have for 1 and 2.
Your Lordship,
1, 2, and 3.
for one, Your Lordship,
Returning officer, you cannot.
yes, Your Lordship, there's a standing council of Panchayati Raj, Your Lordship.
Panchayat Raj, who appears? Who's the standing council?
Miss N. Anju is for representing them.
Madam Anju, are you around in the court?
No, Your Lordship, she's not. there.
Outside the court.
Then you have to take steps.
Yes, I
Yes, Your
will.
Lordship.
And member secretary, you have to take steps, and both the others are all private respondents.
Yes, private.
One, why did extra copies be served upon him? Steps for service of notice upon the respondables 2, 3, 4, and 5 be taken by speed post with ED. Steps within 2 working days. Para. Let notice be issued on the interim prayer also. Para.
Yes, Your Lordship.
Till the returnable date, it is provided that the post held by the petitioners are not to be filled up by any third party.
Obliged, Your Lordship.
Item number 2.
May it please your lordship. This application is filed under Article 226 of Indian Constitution. My lord, that the petitioner is aggrieved by the non-payment of compensation. The land which have been acquired by the respondents for the constructions of Trans-Arunachal Highway and project has been completed. Still, I'm aggrieved by the non-payment of the compensation.
Award has been passed.
Compensation amount,
Award.
not yet. No, initially, assessed amount was determined by the Deputy Commissioner, Ulverswan District. And I was not satisfied with that and I raised objection for representation. But it was not addressed by the properly addressed.
Now, if you are not aggrieved, if you are not satisfied with the amount, it was the acquisition was under which act?
That was 1947 Act. Sadia Balipara Tirap. That's all Act. And this was challenged in this Honorable High Court. And it was judgment was in favor of appellant.
No, if you are aggrieved by the quantum, the compensation amount, you can you can file a reference. You can put an application for a reference. Did you do that?
Yes, final I served legal notice also, and in reply, legal notice.
This is not for a reference. Did you pray for a reference? Yes, Madam, one more.
My work has already been completed, my lord, and here my work has already been completed, my lord.
No, it's not regarding the completion of the work. He is seeking a fair compensation. He thinks that the compensation has been assessed
Yes, my lord, but
inadequate.
yes, but I can't say, my lord, now, my lord, because I don't know whether the petitioner has received the compensation amount or not, my lord.
Have you received anything?
No, not yet.
Nothing.
Nothing.
I have to take instruction, my lord, regarding that, my lord.
My lord, but in reply to my legal notice, Deputy Commissioner claimed that they already paid me. So my submission would be call for record, maybe.
Deputy Commissioner says that you have been paid.
Yeah.
Paid,
Yes.
paid in your bank account. Where? You get
I'm
this
not
instruction,
aware of
madam?
that.
Yes, my lord.
What is your name?
Titunka.
P.
Tunka.
T. Tunka. Okay. Heard T. Tunka, learned counsel for the petitioner who is aggrieved by non-receipt of compensation for acquisition of land for construction of the Trans Arunachal Highway bracket 14-Bopi Road, Yazali sector. Full stop. It is submitted that though the Deputy Commissioner has claimed to have paid the compensation amount, the same has not been received.
My lord.
Let notice be issued, returnable on 9th of March 2026. Ms. Wangmo, the Learned State Council accepts notice on behalf of 1, 2, 3.
And 6, my lord.
What about 4?
4, my lord, I am appealing.
1, 2, 3, and 6. 3 are secure Learned Standing Council PWD.
My lord.
For 4 and 3 M Kato, Learned Deputy SGI for 5. Let extra copies be served. Ms. Wangmo, the Learned State Council is directed to obtain specific instructions and also the relevant records to support that the amount was actually released to the petitioner.
Hello.
What about the other case? What is the other case? 49? Same.
Already passed. There was item number 1.
Okay, why this is there?
Item number 3.
Lordship.
Lordship, tomorrow, Lordship, I have already passed the instruction, Lordship, that he will furnish the instruction tomorrow, Lordship.
This is with regard to what?
With regard the investigation, Lordship.
Investigation.
Up to date investigation, Lordship.
The status report was called for last occasion.
Okay. Heard 3 SK Dewry, Learned Counsel for the petitioner. Para. Ms. Al Hage, Learned Additional PP, Arunachal Pradesh, has however submitted that in terms of the earlier order dated 4/2/2026, instructions have been sought for, which is likely to
Yes, sir.
be obtained by tomorrow.
Yes, sir.
Sarah, in view of the above, list this case on, we'll have it on Monday.
Let it be on 23rd.
In view of the above, matter is adjourned, full stop. As requested, list on
23rd.
23rd would be too long.
Too long, my lord, but I will be.
Adjourned, full stop. On the request of Sri Deori, the learned counsel for the petitioner, list on 23rd. Get it, okay, by 23rd.
Much obliged.
Item number 4.
May I please? My lord, before I make submission, my lord, if the learned counsel or the respondent agrees, my lord, this matter may be remanded back to the state officer, my lord, for final adjudication, my lord. My matter is regarding, my lord, what a complaint was made against me that I have encroached the setback of the quarter.
You have?
Encroached the setback of the quarter, my lord. Quarter.
Backside of the-
Backside of the quarter, my lord. And
You have encroached.
no, my lord,
No, that is the allegation.
that is the allegation, my lord.
Okay, then
Then, my lord, what happened, my lord? A notice was issued under section 4 of the Act, my lord. Honorable public premises.
Public premises.
Yes. And during the pendency of that, my lord, proceeding, my lord, an interim order was passed, my lord. And it was directed that I should, my lord, construct a, my lord, retaining wall. Because of that, some art cutting, that quarter is in verge of collapse. That's why the learned state officer has directed me to construct a retaining wall, my lord. Against that order, my lord, the respondent number 4 appealed before the deputy commissioner, who was appellate authority under section 12 of the Act, my lord. And this deputy commissioner has passed an order, my lord, which is challenged before this sort of court, to seal my apartment, my lord, that house, my lord, which has been built by me. Actually, that is my extension of quarter, my lord. I have this because, my lord, this quarter is type 1, my lord.
the pleadings are over. We can have this for admission hearing.
Lordship, this matter may be taken up for admission hearing only, Lordship, because
We'll have it for
In-
admission hearing
in the,
on Wednesday next for disposal.
this can be taken up now also, Lordship. Can this? Because Lordship, this is a small store.
Today it may not be possible.
Otherwise, my lord, what, my
We'll
lord,
have it on Wednesday.
otherwise,
But we'll make an observation that it will be for admission hearing
Yes,
when an endeavor will be made for disposal of the matter.
yes, Lordship.
Heard Sri H. Lampu, learned counsel for the petitioner. Also heard Ms. G. Ete, learned state counsel. You are appearing for whom? Four. What is your name?
Jiru.
Sri so-and-so learned counsel has appeared on behalf of the as per number 4. Full stop. It is the learned counsel for the contesting parties have jointly submitted that pleadings have been exchanged and the matter can be taken up for disposal at the admission stage. List for admission hearing on 18th.
Lordship.
18th.
Lordship, can it be on 19th? I am not here on it.
19th is the DB day, but we can still have it Thursdays and Tuesdays. We have been told it's a DB day.
Let it be on 17th, Lordship. Tuesday.
17th, Tuesday and Thursday are DB days. On Friday then?
Yes, Lordship, Friday.
Friday is a holiday.
Holiday, man.
23rd.
23rd. Yes, Lordship.
23rd. 23, yeah?
Much obliged. Item number 5.
Interim order passed earlier to continue till the next date of listing.
Your Honor, this is standard matter. I am for petitioner, Your Honor.
Yes.
Petitioner is a class 4 registered contractor eligible for the bidding capacity of rupees 1 crore. and it's belong to the Paga blades under Bipin Sagali Assembly Constituency, which is given in Annexure P1, page 16.
Yes.
NIT issued for package of the work under Bipin Sagali Assembly Constituency, wherein the petitioner firm is eligible for 4 unit type 2 quarter at Government Higher Secondary School, Toru, Papumpara district, with the estimate cost of rupees 93,000, 58,000, 93 lakhs 58,000, with certain terms and conditions. In the tender was notified on 12 March 2025. But my availability of with documents was restricted to just 3 days from 13 to 15 March 2025.
Yes, what is the present status, Mr. Tarak?
My building is complete.
What is remain to be adjudicated?
Yes, nothing remains.
Even if you are successful, you cannot get it reversed.
Your Honor, earlier we have asked for status quo, but
it was not given. The building is completed. No point here. This will be only an academic exercise. If you see your prayers were challenging the entire tender process. Now the work has been completed. And the tender process started in the year March 2025.
Yes.
But Your Honor, this is a man-made urgency, Your Honor, because we have not given enough ample time.
That you can make out a case, but it will only be academic. You raise your grievance in an appropriate case. If there was an interim order of status quo, matter would have been different. Now that is our concept. That is what we are trying to find out, and Mr. Tarak has also said.
Nowadays, Your Honor,
close this petition. Okay.
Your Honor, nowadays same.
We'll say that we are not expressing anything on merits. If you raise a similar challenge subsequent for future projects, will be answered in accordance with law. What is your name?
C. Peter.
Your name is not there on record.
Yes, Your Honor.
C.
C. Peter.
C. Peter. Okay, you got it. Heard C. Peter, learned counsel for the petitioner. Also heard G. Tarak, learned standing counsel RWD. Tarak. The instant writ petition was filed with the following relief. You come to page 12, extract the prayer portion, okay? As for the facts projected, comma, the tender notice was published with an unreasonably short bid window of only 3 days. Full stop. Such recourse has been alleged to be in gross violation of clause 4.13 within bracket Roman 2 small of the CPWD Works Manual 2022, which mandates clearance of 14 days. Full stop. Various other grounds have been urged in the writ petition. Full stop. Para. This court has, however, noted that though this writ petition was instituted on 28/3/2025, comma, notice was issued only on 5/5/2025, and no interim order has been passed for Sri Tarak, the learned counsel for the department has informed that the work in question has been completed and the constructions are over. Para, in view of the efforts of development, the adjudication of the present list has will be mere academic. Para, in that view of the matter, the writ petition is closed. Full stop. This court, however, makes it clear that no observation on merits have been made, and any aggrieved party would be at liberty to urge the same grounds in an appropriate case in the future.
No. Masood.
Item number 6.
Item 6, Mr. Lampu.
Yes, my lord. My lord, this is the settlement of pension papers, my lord. Some urgency is
Pension.
pension papers, yes, my lord.
Done or not? Till now?
Not done.
Because of some anomalies, Lordship.
Anomaly is right.
Lordship, because
Pension should not be delayed.
Yes, my lord. My lord,
understood, Lordship. Gratuity, everything has been paid up only with regard to the pensionary benefits, Lordship. Because
When are you? When can you sort it out? You have filed your response.
a response from AR department and the audit and pension, both, Lordship.
the issue is very simple, my lord. My lord, in the year 2003, my lord.
No, how do you sort out the anomalies?
Because the Lordship, there is two schemes being followed, Lordship. One is MSCP, SCP, and another is TBS, time-bound scheme, Lordship. The petitioner was to get the TBS, whereas after promotion to AE, he has been given MSCP, Lordship. That has to be recalculated, Lordship. That's
So
right.
you have to do that. This matter is pending since
Lordship, that has to
2025.
be done by the department, Lordship.
Which
That's
department?
retabling.
Oh, my
The
lord.
power
Which is your parent
department.
department? Power department.
Power
Power
department.
Yes.
My lord,
yes.
sir,
We have a Lordship sent it back to the department for.
You are for the power department.
Appearing on behalf of anybody.
Where is he?
Saving some personal.
The administrative department has to sort out. Pension cannot be delayed.
Lordship.
And notice was
Understood,
issued.
Lordship. This is
When are you expecting Mr. Permit to come back? Monday? We'll fix a date. We cannot pension matters.
my lord.
Hertz Free H. Lampu, learned counsel for the petitioner, who is aggrieved by non-receipt of pension. Miss G. Learned State Council has, however, informed that there were certain anomalies and the matter has been referred to the administrative department, namely the power department. Para?
no parent department, Lordship,
Parent
not
department,
administrative.
the parent department, namely the parent department, that's power department. Parent department, namely power department. However, a prayer for adjournment has been made on behalf of Sri L. Perme, Learned Standing Council Power, on personal grounds. Para, considering the subject matter involved, while adjournment is granted, the matter is directed to be listed on Monday next. Give the date, please. We'll have it on 16th.
Lordship is fine by me.
16th, you'll be there? Yes. All right.
Obliged.
Item number 8.
My lord, I am
Item number
appearing.
8 to 10.
Told that the IA will be coming short. All right, it is coming on the way. It's all right.
One is already there.
My lord, that is earlier, it was regarding maintainability, we have crossed the stage. Actually, my lord, this is the case wherein, may I submit, my lord?
Very well. Just a
Main
minute,
case.
just a minute, Mr. Pravara, just a
Yes.
minute.
It raises substantial question of law and
Just-
procedure
just-
pertaining to.
Just a minute, Mr. Pravara, just a minute. This IA of 291 of AP was filed for what purpose?
It was pertaining to maintainability of the writ petition
Okay.
because there were disputed claims. And at that time,
Does it survive?
my lord, it does not, this is going to be our submission now because acquisition proceeding is complete. We have deposited the money with the treasury also.
Money
So-
has been deposited.
It has already been
So
deposited.
what is the grievance of Mr. Borbora?
The grievance,
Allow me,
Yes,
Lordship will allow me 10 minutes.
Yes.
It is not only quantum of compensation, or my lord, what they are depositing. Substantial question of law and procedure pertaining to acquisition will be for adjudication by your lordship. Nobody challenges the public purpose behind acquisition. I have also not. So there are, and these questions have emerged more from the affidavits and the documents filed by the state government so far, and also by NSPC. Allow me 10 minutes, lordship. My lord, lordship may take up 247. That was the first case. Then another case was filed that was taken together subsequently. 247. My lord, instead of me narrating the facts, my lord, the first order itself, this court has narrated the facts. Lordship may go to the order dated 2625. 26.
26 or 66?
Yes, my lord, this is slightly wrong order, but
66.
even then, let me read it.
26 or 66?
66, I'm sorry, 66.
Yes.
Submits, paragraph 2, that two petitioners are owners of 315 hectares of land at so-and-so circle out of the said lot. Neither of the affidavits have denied that we don't own it. The government has issued notification in 2013, 2713 under section 4 and 6 of the Land Acquisition Act 94 and acquired 66.6 acres of land from out of the petitioner's aforesaid parcel for the purpose of multi-purpose project, Lower Dibang Valley. For the user agency, they are the requiring body, National Hydroelectric Power. By paying appropriate compensation thereof, and petitioners, my lord, user agency entered into, entered into an agreement, my lord, and we surrendered the land. No problem with that. That was my land. I got compensation. I surrendered merrily. Third paragraph. Submitted that thereafter petitioners have noticed in the month of October 23, this was a petition filed. Compensation I got in 2021. October 23, we noticed that along with the ongoing construction installation works undertaken by NSPC, over the 66.8 hectares of land acquired originally owned by the petitioner and lawfully, NSPC has suddenly started cutting trees, medicinal plants, standing matured plants, timber, bamboo grove, so-and-so, petitioner's land falling outside the area of 66.6 hectares of acquired land without their knowledge, consent, and without any communication whatsoever by the government of Arunachal Pradesh. So acquisition proceeding is not for the NSPC. It is for the government, as your lordships know. They simply deposit the money that comes from central government. Coming to next. Submitted that petitioners have filed various representations, including Chief Secretary to the government, but the same failed to evoke, and therefore this writ petition. 5. Submits that respect of cutting trees and other construction installation work undertaken by NSPC over 66.68 hectares of land, we have no objection. But the petitioners have objected in cutting various trees, medicinal plants, standing, matured plants, timber, bamboo groves, and fruit gardens over the parcel of land area over and above. Under article and rights violates article rights under Article 300A and other fundamental rights. Submits that at this stage notice may be issued, respondent authorities may be directed not to undertake any works cutting trees beyond the acquired area of 66.68 hectares. Mr. So-and-so, Additional Advocate General submits consent if the concerned NSPC has undertaken any cutting trees. Having heard, now the operative portions, 2 paragraphs. Having heard counsel, both parties, I have carefully gone through the petition and documents placed on record, and taking note of the submission of the learned counsel for both the parties, and also considering the facts, the court is inclined to issue notice so-and-so, 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 then so-and-so has entered appearance, however requisite. Then paragraph 8. Further, taking note of submissions of the learned counsel for the parties, it is provided that the respondent 1 to 5, all, shall make a field survey. Lordship, mind the word, survey.
Yes.
It is not eyewash verification. Survey, I'll come what survey is all about.
comprising regional responsible officers from the concerned department and authorities in presence of the petitioners and the village headman, and to submit a report within 2 weeks from the date of receipt of the copy. Further provided that till submission of the said report, no activities should be carried out beyond the area of land already acquired. So this is all about first area. And although they continued with the construction, I didn't come up for any contempt because I don't derive any sadistic pleasure by filing a contempt petition, and I am bothered about the main case. Another order was, Your Lordship, kindly 18/8/25. Person to death, 2 months thereafter. This court on so and so, having considered that learned additional advocate received field in verification survey report, this says field verification, I'll go to that, which has been carried out as directed, granted time to file the same being on record by an affidavit. 3 weeks time. Prayer is allowed. However, within 3 weeks, in the meantime, may file a detailed counter affidavit, also bring on record the aforesaid report in an affidavit. Not 3 weeks, my lord, for about 4 months, they didn't file any affidavit. And finally, they filed it, my lord, respondent number 2, paragraph 5 of the government affidavit I will refer, that is dated Kotgal. Yes, government affidavit, my lord. Ultimately, they filed in December 3, paragraph 5. Paragraph 3, they have said acquired land.
Paragraph?
My lord, Lordship may come to page 118. It is a very long paragraph. 118. 88. I'm sorry, 188 running page. Instant petitioners representatives of Mimic Land, 188. Yes. The paragraph starts from 186. I'm coming straight to 188.
Yes.
188. Top. Representatives of the Mimic Land, 66 already acquired out of so and so hectares of land was notified, and the matter of ownership of overall 317 hectares of land was not part of the acquisition proceeding. This 317, I am the owner, my lord, and my family, ancestral land. Parcel of 66.6 hectare land is part of 144 hectares of land notified, serial number 17, and the claim of 66 hectares was recognized in favor of Mimic claim. This is what they have shown. Then, my lord, Lordship may come to page 208.
कुछ भी नहीं है मेरे पास
208. From this document given by the state affidavit, it was by the land management secretary, certain important revelations emerge. This is at page 208. This is of 16th of June, 2025. The first order was of 6th of June. This was 16th of June.
Yes.
On the top, it is written to the deputy commissioner by my lord, different officials, DFO, Forest, and my lord, EAC, ADC, are all signatures are there. Top joint verification report. In pursuance of the order dated, that is this case, dated 6/6, undersigned group of officers constituted a good self-conducted joint verification of the site, ascertain the activities being carried out, any species, beyond extent of 66.68 hectares acquired land in presence of so-and-so head Gaumbuda, that is my head Gaumbuda, and petitioners, me. The following activities are observed in the area beyond the acquired land, as giving. That means beyond, after 6th of order, on 16th, they observed that beyond the acquired area, which supports my allegation, they have done the following activities. 1, physical works are being carried out beyond the acquired area of land measuring so-and-so hectares, which was acquired, and I surrendered this. This has been accepted and confirmed by the representatives of the NSPC. This is the admission that yes, we are constructing adjacent to the area which were not acquired and compensation for which was not paid to you. It is beyond that area, outside that area. Rowing present site during verification. Then 2, construction of 1 access tunnel, earth cutting works for road. NHPC rowing representatives have been instructed to stop all such activities beyond. He was instructed, but it was going on, never stopped. And I'm not on that. An additional 30.76 hectares of land is being proposed to be acquired. Lordship may mark it. Is being proposed. Date is, this letter is 16th of June. So on 16th of June, 2025, the responsible government by officer, they say that it is being proposed to be acquired. Just note this. Around the acquired land, multiple applications claiming landowner, same owner received. It's all right. There are people, here is one, here is 30 hectares, out of 30, I may 20. He may claim, the other petitioner may claim another 7 hectares like that. Claims are multiple. That doesn't merely make it disputed. Then, my lord, next page, there is a map. Page 209. 209. It says, Lordship has just turn around it. It is annexed other way.
Yes.
It said, breaking point, acquisition of additional land for construction, verification report index. The word is again verification. Plot number 1, so and so hectare, plot number 2, so and so hectare, plot number C, so and so hectare, total area so and so hectare. Now, after filing this affidavit by the government, certain important developments took place. Lordship may turn to page 226 and 227. Yes, in our reply affidavit, page 226 and 227. I'm just giving their affidavits, then I'll come to the questions of law, which are very serious, and procedure. This is a letter of 8 September, whereby the additional deputy commissioner of Dambuk Circle, it is a subdivisional additional deputy commissioner. He says your claim of rightful ownership over the land notified against 17.62 hectares, Lordship may mark it, on the right bank, will be heard on so and so date at my office. That is a hearing. You are requested to come with all documents and then all these things. On 16/9. On 16/9, we went there. By the next page, that is 10 days thereafter, I was again called. Below is my name, my lord, the petitioner, 2. By that additional deputy commissioner. By the another letter by the ADC, I was invited this time for 68.8 hectares. The earlier letter was 17 hectares, Lordship mark first paragraph. You claim for rightful owner over the notified area of acquisition of 68 for construction on the right bank of so and so. Therefore, you are invited to come. On both dates, I went personally with the Gambura and the head Gambura and my family and other descendants of my ancestors. And I also submitted written submissions and documents on both the dates. We don't know what report that additional deputy commissioner gave. It is not before this court. It is not annexed by the government affidavit. We went.
First up. 237. First. Okay.
Wait. Then another 2 notices, both on the same day.
Yes.
This time by the deputy commissioner himself. This affidavit was, government affidavit was filed on 3/12. Therefore, that was not updated affidavit because there was subsequent to filing of that affidavit by the government. Two notices came, this time from not ADC, directly from the Deputy Commissioner, which your lordship will find at page 237 and 238.
37 is by ADC. And
237, it is by the Deputy Commissioner.
Sir, additional deputy commissioner.
Wait, second one is by for Deputy. Here, my lord, 4017. So process was 17. So this time the Deputy Commissioner said, no, you come to my office directly.
237 and 27 are same.
But the
Same letter.
area of land is different, my lord. Kindly see.
Area is 68.88. Same.
17 point, no, first page 237.
237 and 227 are the same.
Right, 237 is, my lord, 17.62 hectares.
ADC.
And date for appearance was 3012.
No, that is 226.
226, right.
There are two letters, Mr. Borbora.
Right.
One is at 8/9/2025
Right. I
and
think,
226.
yeah.
ADC gives you notice. We'll have a hearing on 16/9/2025 for an additional 17.62 hectares.
Yes, and the other one,
227 is a letter of 18/8/2025. Another notice, hearing on 29/9/25 for 68.88
yes,
hectares.
that's,
We have
one page, my lord, here, I think double written, in my copy. Yeah, absolutely, that's fine. So we attended both the days.
yes.
One in respect of to 17 hectares, and the next day in respect of 68.88 hectares. Now, what report the Deputy Commissioner has prepared? It has not come. These are all subsequent to the affidavit filed by the government. Here, on the last date, I insisted on production of this report by the government. This court latest order dated 2/2/26. That they said that the matter has become infractious, actually. It was written like this. S.C. Borbora, so and Soikia fairly submit that although there may not be any surviving issues, no, because I already filed this. Certain developments, however, in view of that has been said by, may not be surviving. Actually, it was the submission of the government that matter has become infractious. Anyway, however, in view of certain developments, including proceedings of acquisition as well as notice issued to the petitioners by the Deputy Commissioner for hearing, which was scheduled and has already been heard, the prayer prays for listing of the matter on 12/2 so as to enable the state respondent to place it. On the next date, so-and-so, counsel for NSPC, as well as so-and-so, additional Inspector General, to obtain up-to-date status report to bring on record by an affidavit. Counsel for disorder, list the matter on 22. So that affidavit has not yet come, be that as it may be. Now there are certain crucial questions. Meanwhile, NSPC has filed an application challenging the maintainability of my questions, that there are multiple claimants, but for reasons best known to the NSPC, although on 3 days it was listed, it was not moved by them. And I'll go to the extent of submitting that today it should be moved and the maintainability question should be settled. Why, if it is not maintainable, I'll out of this court, why should I unnecessarily waste valuable time of your lordship? That will, your lordship will see. And for that, since it is I have filed by him, he will submit. Now the questions of law. Crucial. Appreciating that it is for a public purpose, lands are acquired by NSPC for a dam and ancillary works, we willingly and merrily surrendered, my lord, in 2021, 66 hectares.
So, Mr. Borbora, we can have the report of the government. See, your grievance was the activities which were carried out beyond 66.68 hectares of land, which was the initial subject matter of acquisition. You came before this court, and in the meantime, it appears that the joint verification report had proposed further acquisition of land.
I'll come to that.
If those acquisitions are done and
Yes,
compensated
very right.
in fair manner,
Your
then
lordship,
you may not have a...
No, I am going to the root of the matter.
No, Mr. Nabam.
You have to come up with a comprehensive affidavit.
That is it, Nabam, Mr. Nabam. What is your call on this? What is the, after hearing was called for by the ADC for acquisition of 2 in two different, for two different areas. First is 17.62, the second is 68.88. Now, has it been culminated?
My lord, so far, my lord, the notice issued by the deputy commissioner to the petitioners, my lord. Yes, my lord, what sort of action they have taken, my lord? The deputy commissioner has given me the instruction. And prior to that also, my lord, there was a direction from this court to make a verification report, my lord.
Yes.
When you see both the reports, my lord, there is a, my lord, dispute of facts are there, my lord. That cannot be overruled, my lord. Who is the actual owners, my lord? I have, my lord, both the reports, my lord, you not see my parents.
No, Mr. Nawab, if there is a dispute with regard to who is the owner, those we can adjudicate later. But the verification report, which has been enclosed at 208, 16/6/2025,
correct, my lord,
has prima facie come to a conclusion that beyond 66.68,
my lord,
there are activities going on.
correct, my lord.
And therefore, to ameliorate the problems, to meet the grievance, if you have additional acquisition of land, matter ends there, provided fair compensation is paid. Now, to get the additional land acquired, 2 hearings were conducted.
My lord.
We want to know the outcome of those.
My lord, yes, my lord.
Now, who will be the owner? Who will get the compensation? That will come later on.
And there is one more question. I'll come, my lord. Yes, there's something.
And probably in that case, Mr. Tiwari may not have any grievance at all, or he is not required to be.
He is the requiring body. His job is to construct. The job of doing proper acquisition under the law and following the process is for the government. And that is where.
But the petition duty is to receive the money.
Anyway, my lord, that's one thing. Just
the deposited the compensation amount of so 66.
That is additional, no? 17.
Additional to 17.6268, both areas.
Both are additional.
And money paid.
On disputed questions also, I will refer to Supreme Court.
Mr. Tiwari says that for both the additional amounts.
He has deposited, my lord. We are not. But the question, one question, that crucial question, my lord.
Yes.
I know that lot of acquisitions are going on. Actually, I am feeling emotional today. Because last time, in another case, I was brought by Sabzarabha. That time the acquisition was through forest. And I am not, anyway, life goes on for your lordship and me also. That day also, that was done. A lot of acquisition cases here. That was regarding not this done. Forest land, highway going through forest.
Now,
land.
what do you propose here?
Here, my lord, important question will be, does it allow the state or central government undertaking to go on construction works in areas without first lawfully acquiring it? Can there be any post facto acquisition? No. Good. Purpose is good. We surrendered land. You go ahead. Can it be allowed? Now, kindly have a look at page 208 once again. Proposed acquisition and which date if they have proposed it in 2025, the land acquisition original act will not come. The 2013 act will come. That your lordship will have to adjudicate here. Kindly have a look at page 208, government of India.
Now, Mr. Barbara, one question will come. If you are on the route of the acquisition proceeding, then our approach would be slightly different. You may have a very good case that you have not followed 13 Act.
Yes.
But will an intervention on that point be in the interest of the justice, interest of the state, interest of you? You are interested to have a fair, reasonable, and adequate compensation for your
Based on proper survey. That has not been done.
That will
That has not been done.
See, if you insist on the preliminary notification, the final notification, in that you can make out a very easy case. And for us to intervene on a point of law may not be in the interest of the justice. And the interest of the state, because there is a huge project coming up.
No, we have got nothing to do. Works are going on. But there.
So now our concern is that whether you have been paid adequate, fair compensation as which you are entitled in law.
I am raising one thing, that additional land, you have acquired these 70 hectares. You go alike whenever you want, start construction, and then you propose an acquisition. That means post facto. Is it allowed under the law? After all, all of us are under the rule of law. No. Good purpose. We are not opposing construction of dam, never. Earlier,
how-
2001, we surrendered.
You see, you're a seasoned person, you're a senior person. You suggest how do you overcome this kind of a
There
situation?
has to be a proper and scientific survey. Kindly have a look at page 208. Again and again, they are saying verification. This is IWAS. Kindly have a look at page, my lord.
Mr. Nabam, how have you arrived at these figures
No, no.
which Mr. Tiwari's client has deposited?
My lord,
You have arrived at two figures,
my lord,
one for 68.88, one for
my lord, the
17.62.
68 is here, my lord.
No, you have given it, action
Yeah,
taken report.
I have
Now,
referred to
this
that.
figure was arrived at, how did you arrive at these figures?
My lord, perhaps, my lord, the moment, my lord, they made an allegation saying ki NSPC have exceeded beyond the allocation. That's why, my lord, subsequent, my lord, the proposal has come up to cover up that, my lord.
No, Mr. Nabam, we are not on that. See, we want, how have you arrived at these two figures?
My lord,
We have understood that initial acquisition was for 66.68. They noticed that beyond this 66.68, there were activities, cutting of trees, and so the grievance was made. In the verification report of 16/6/2025, there was a proposal to acquire further land.
my lord.
That will have to be under 2013 Act.
Further land. Now, issues are raised on a very legal point, whether without there being a notification under the 13 Act, whether you can straight away assess. But we are on a different point. That point
My
we'll
lord, you must
consider
be asking, my lord,
that this amounts of 14 crores and 41 crores, you have arrived at, how did you arrive at this
my lord,
figures?
that amount, my lord, I believe, my lord, after proper assessment, property,
No,
whatever, everything, my lord.
you put on affidavit.
My lord.
You
My
put
lord,
on
Let them put on.
my lord, without
See,
any
we
proper
can
assessment, my lord.
at this point, we cannot, there is no question of finding fault at all with Mr. Tiwari. Whatever you have said,
No, he has deposited.
he has
the money.
deposited.
My
Yeah.
lord, just a minute. My lord, we have made a proper assessment. They never raised, my lord. An assessment was approved by the government, then it was sent to the NSPC. Now NSPC, they have deposited and will pass the award and money will be dispersed, my lord. Till then, my lord, they have not raised. Your lordship may kindly note, my lord, they are saying, my lord, they are representing the Miami clans, my lord. There are so many clans are there, and there is, my lord, counterclaim of the ownership, my lord. That exactly Deputy Commissioner says, my lord. As on that, Deputy Commissioner failed to arrive, my lord.
No,
Who is the actual owner?
Mr. Nabam.
We may
unless-
settle it amongst
No,
us.
unless somebody disputes their claim.
Another petition is there, my lord. Second
two
petition.
petitions.
Two petition, my lord.
No, it's all right. This is amongst us.
Conflicting claims are there.
No, no,
Both
it's
the
all
claims
right.
are
As
there.
I said at the very beginning, he may own these 15 hectares, I may own
Who
this.
is the other petitioner?
My lord, we are concerned about that.
Madam, Bohemi Mimi says he is the owner of the entire land.
No,
Okay, that part,
that can, we will see.
that part we'll consider. How do we deal with it?
My lord.
You put on record, on affidavit, the manner how you have assessed the steps taken, put on record by way of an affidavit.
And what's
Let everything be transparent. Let either Mr. Borbora or what is your name? Sorry, we got it.
P. Garam.
Garam, Mr. Garam. They will be knowing what is the procedure adopted.
And we may sit together.
Later part, it can be talked out. It can be
It is sorted out, madam. In fact, the earlier tripartite agreement, lordship, similarly, agreement is always with the representative of the clan. Kindly have my agreement tripartite.
Okay, well, let us pass
So
on.
he is
that.
going-
Let us pass on.
His utterance says that he is claiming that, it's claiming no, it is the clan representative.
No, if you are
I'll come to
discussing
that.
different matter, you
We'll-
can shut it out.
Let us pass on.
Question is, did they conduct a proper survey?
Okay, correct. Heard, please wait.
Lordship, may note that.
Well. Heard,
My lord, our IA has also come. My lord, may I, only 2 minutes I'll take.
I for,
IA, my lord. This sir, please.
I for,
There are two IAs in both the writ petitions. This IA, my lord, is seeking a declaration that we have paid our money and that writ petition has been rendered infructuous. Because, my lord, in the
we will record this. Yes,
Very well,
we'll record
very
this.
well,
Then
very
we can,
then, my lord, only one prayer would be there, since, my lord, we have paid the money in respect of,
We'll record. You don't have any,
then,
it
my
should
lord,
not be unnecessary drag.
we are constructing the road, access road to reach the main project site. Work has come to a halt because of the interim order. We are not working contrary to what London Friend says. We are not working at
What
all.
is the interim order?
My lord, interim order was, work was put to a complete halt. And work indeed has come to a complete halt. That is why, my lord, this very IA seeking a direction from the court, at least we can
Barbara,
start the work.
Will you be interested to halt the work?
No, my lord, not, they have not come with a vacation petition of the
No, no.
stoppage order.
No, even otherwise.
No.
This is the prayer
I
we
want
have made in
I want
IK.
a proper survey. I want a proper survey. They have not done. No boundary is mentioned.
That will ensure.
Only hearing, my lord.
Third,
Office,
3 AC Borbora, London Senior Council assisted.
that they have a
by-
comprehensive
Mr. Tara, you
affidavit.
assisted by Sri
My lord,
T. Tara.
1 minute, let there be a very comprehensive affidavit. It is not the job of acquisition proceeding, is not the job of
You
the.
kindly listen to us.
Our job is construction only.
T. Tara also heard Sri R.H. Nabam, the learned additional AG, Arunachal Pradesh. To confirm? Okay. Sri P.K. Tiwari, London Senior Council, assisted by Sri Sungan, appears for the NHPC. Para. Briefly stated, comma, a plot of land measuring 66.68 hectares was acquired for construction of what?
Multipurpose.
Dibang multi-purpose project.
Yes.
Dibang
That is the
multipurpose
name.
project by the NHPC. Full stop. There is no dispute with regard to the payment of compensation for the said plot of land measuring 66.68 hectares.
Which was acquired and we surrendered.
However, the problem started when the petitioners noticed that there were cutting of trees and use of land beyond the plot acquired, which was 66.68 hectares. Full stop. There, this court, while order dated 18/8/2025, had granted time to the government to file affidavit along with the joint verification report. Full stop. The state respondent had accordingly filed an affidavit wherein a joint verification report dated 16/6/2025 has been enclosed, and under serial number 5, there was a proposal for acquiring further lands beyond the initial land of 66.68 hectares. Full stop. It is also brought on record that towards acquisitioning the further plots of land, 2 notices were issued by the concerned ADC on 8/9/2025 and 18/9/2025 respectively. Full stop. By the first notice, the hearing was fixed for acquiring 17.62 hectares, and by the second notice dated 18/9/2025, hearing was fixed for acquiring 68.88 hectares. Full stop. The petitioners claim that they had participated in the hearing, whereafter they were not made aware of any finalization. Full stop. Para. Sri Nabam, the learned AG, has placed before this court an action taken report issued by the prepared by the Deputy Commissioner Lower Dibang, which has been forwarded by letter dated 5/2/2026. Full stop. As per the same, both the acquisition proceedings have been completed and the compensation has been assessed. Full stop. It has also been stated that the NHPC has deposited an amount of rupees 14,26,66,914 bracket meso in respect of the acquisition of 68.88 hectares of land, and another amount of rupees 4,51,44,486 bracket pura in respect of acquisition of 17.62 hectares of land. Full stop.
That matter page 236(7).
Full stop. At this stage, the learned senior counsel for the petitioners has submitted that that the action taken report would indicate that no procedure under the Act of 2013 appears to have been adopted, and in a mechanical manner, some assessment has been done. Full stop. He, however, fairly submits that it is only on the aspect of receiving a fair, just, and adequate compensation in accordance with law that the petitioner is concerned. Petitioners are concerned. Para?
Then this is letters.
Sri
230.
Tiwari, the learned senior counsel for the NHPC, has submitted that though certain issues have been raised, it apparently appears, it is apparent that such issues involve disputed questions not only of facts but also of the claims of two different sects of the
Clans.
clan.
No, it is same plan.
Clan is same, individuals are different and
Two
each
different
individual-
groups of the same clan.
Yes, yes.
Sub-clan.
He has also submitted that since the assessed amount has been paid by the NHPC, his client should not be dragged into the present proceeding.
And we should be allowed to start the work.
Full stop. He has also indicated that because of the interim order passed by this court, the work has come to an halt, which is adversely affecting not only the works but the interest of the public.
Yes, because the road is under construction.
Full stop. Para? After considering the facts and
My lord,
circumstances.
sorry. 18 December again, DC called, Lord, subsequent to their affidavit. 18 December, page 236, 237. This time by the Deputy Commissioner himself.
That is a
The process is on.
Okay.
Calling people.
Three, okay, ma'am. Last name? Huh? Last line. After hearing the learned counsel for the parties, this court is of the opinion that a detailed affidavit is required to be filed on behalf of the Deputy Commissioner, Lower Dibang Valley Rowing, to put on record the procedure adopted for the assessment and as to how the amounts in question were arrived at. Full stop. Such requirement, such a recourse is required so as to ensure that a fair, reasonable, and adequate compensation has been paid to the land affected persons.
Based on survey as mandated by the 2013 Act.
Full stop. As regards the aspect that two groups of the same clan that there is a dispute between two groups of the same clan who have filed two writ petitions, the aspect would be taken up at the appropriate stage. List on when? List after 3 weeks? We give you a date, Mr.
My lord,
Bourbon.
this consideration is not, my lord, has become in practice that this proper survey is not conducted. That is still for your lordship.
Yes.
That may be recorded.
First, let us see how the assessment
It will
is
be
done.
It will be open.
Yes.
My submission may be recorded.
Yes.
This may be recorded.
Okay. The submission made by Sri Borbada, the learned senior counsel, that assessment has been done without making a proper survey would be under the 2013 Act would be considered at an appropriate stage after examination of after perusal of the contents of the affidavit, which is directed to be filed by the concerned Deputy Commissioner. Para? List after 3 weeks.
Meanwhile, we'll be at least.
Okay. Yes, we will.
My lord, lordship may allow them.
As regards the
Keeping open the, my lord.
as regards the
Questions.
as regards the restraint order by which the work has come to an halt, Sri Borbada, the learned senior counsel, has very fairly submitted that the primary purpose is to ensure that his client is dealt fairly and
under
not
the law.
to restrain a public work of public importance. Full stop. Correct. Considering the above, while considering the one, this court is of the opinion that there will be no restraint on the part of the authorities to carry out the work, including the construction of the access road in accordance with.
This, however, will not preclude the whether the survey was conducted.
Yes, the present order for allowing the construction work would be without prejudice to any rights of the petitioners which have been raised in this writ petition.
Let a date be fixed for him to file a comprehensive.
Yes, you tell us.
Then Lordship may, no, let that.
No, we'll give his, we've said 3 weeks, you say.
And thereafter another 2 weeks for me to reasonable, but very reasonable to file a agenda to their affidavit if necessary. It is the only reason.
Before the interim order, you write, huh? Such affidavit may be filed within a period of 3 weeks, whereafter the petitioner
Will be sent to me, then
3 weeks whereafter the petitioner would have the liberty to file a response within a further period of 2 weeks thereafter. Full stop. Please, this case, 5 weeks, after 5 weeks, that means 1, 2, 3, 4, 5. Oh, we'll have it on 25th of March.
25th of March.
Is it okay, Mr. Barbara? Wednesday.
25 तारीख
25 तारीख मार्च sir.
25
It will be March.
Why sir?
Can it be on 23rd? Yes, Sunday, if I come and Monday, I lose 1 working day only, otherwise 2 working days.
You should come here and take some rest also. And enjoy the.
He's liking the place, my lord. In fact, he likes to come. He likes to come.
I had been to this, my lord, Dambuk place. My lord, 23rd.
23rd
of March.
Possible.
But in that case, Mr. Nabam, you have to file before 9th of March. Please do that.
9th of March, that will be probably.
Sir,
My lord, later date.
No, you file it before 9th of March. It will not be listed. Listing will be on 23rd. If you file on 9th of March, we're giving a copy to Mr. Tara. They can file a response by 23rd.
Correct.
Hello, why I'm saying today is 12, because the affidavit has to come from the Dibang Valley, my lord. It's far away.
You have more than 3 weeks.
3 weeks. Very well, my lord, we'll try, my lord. 23rd.
Or we can have it on 30th. 30.
That the 30th Balbu
38th of March.
30.
All right.
30 of March.
Let them file the affidavit.
Then you file it before 16th of March.
Yes.
Since
What the dates may be indicated. What the dates.
Is it required?
Yeah.
30th we are required. indicating.
since my lord, we can now do the work. We are not concerned about the dates.
You can sleep happily.
Yes.
There should not be bothered about compensation.
30th. You show it to me.
We want to work, that's all.
The action taken report dated 5/2/2026 is made part of the record.
Correct.
Very well.
And why I'm telling about survey and proper, Lordship may kindly have just for page 36 of my writ petition. Page 30.
We'll have this on the next date. Don't
See the valuable timbers they may have lost.
We'll have this on the next date.
Nice photograph, but without any authentic. Nice photograph.
But it was photographed, Mr. Barbara is not there.
It's all done by Mr. Tara.
He had gone to the site itself. I'm yet to see any of the project. He has visited.
My
the site.
curriculum.
Okay,
No, online.
they will sort this out matter. Don't
Sir,
worry.
sir,
And Mr. Garam and Mr. Tara,
My,
sit and talk.
yes.
You should not have dispute amongst yourself. You are fighting together.
My name may be, Lordship, recorded in item number 10, Lord.
Sri Garam, learned counsel.
He also appears.
For the, petitioners.
Petitioner, Lordship.
In Mr. Barbara's case, how many petitioners are there?
Two.
And item 10 to more than 2 petitioners, both petitioners. Okay.
All right.
Similar.
Item number 11.
There'll be one order, huh? One order. So, ऊपर में लिखना. Anti Garam for the petitioners. Yes, Mr. Item number
11.
11.
So that's your for whom petitioner?
May I, my lord? This is a petition, my lord. You take your time.
You're for the Arunachal University.
I'm for the petitioner, my lord.
Arunachal University.
Yes.
Yes.
My lord,
Why have you come university? What do you need?
there's a overwarrant petition, my lord. Questioning the appointment as well as continuance of response number 4. As chairperson of regulatory commission.
Of?
Regulatory commission, regulatory commission, my lord. Now,
He was earlier appointed as chairman in the APSC, that is Assam Arunachal Pradesh Public Service Commission. And that is contravention to Article 319D of the Constitution. That is a short question before your Lordship, my lord. It's purely little bit of facts as well as question of law matter. Article.
May I, my lord?
Just a minute. You're for whom?
Yes, my lord, I'm today appearing first time for the respondent number 4, my lord.
For his entire appearance.
Yes, my lord. I'm
I'm
asking
you're
time.
challenging the appointment of 4. Which
My lord, I'm seeking time for filing
you will
affidavit.
grant you time, don't worry. You are, Mr. Das, you are saying that his appointment is in contravention of 319.
Article 319D of the Constitution.
Let us see, what is it? Constitution of India. Reappointment is
Because-
barred.
Because once a person who is a chairman, he ceases to hold the office of RDS Commission, he cannot be appointed in the same state. He can be appointed somewhere else. Article 319, prohibition as to holding of office by members of commission on ceasing of to be such members. Now we are concerned only with D. But not for any other employment, either under the government of India or under the government of state.
He was earlier what?
He was earlier appointed as Arunachal Pradesh Public Service Commission.
Member.
He was member. Your Lordship may just have an.
But why are you concerned, university?
Mother, I mean,
It is okay, you are praying for a writ of quo warrant so that we can understand.
Mother,
Why should the university be bothered?
that is a question because he is holding a public office and I am the university where he is the chairperson of that particular regulated commission, Mother.
No, but university, why are you questioning? You are a statutory body.
Yeah.
You are not somebody who is also interested in that post, that because of his illegal appointment, you are being deprived. Why should the university question?
That's a question, my lord. But purely, one is, my lord, the law says that anybody,
No,
if
that is
you're
okay.
if you're
No,
if
no,
you're holding
Mr.
a post
Mr.
unauthorized,
Das, we are exercising equity jurisdiction. We also look into your, who are you, who is the petitioner? What business the university has got to come to the court questioning and we're praying for a writ of quo warrant to?
yes,
It seems that one of your officers is against this response number 4. Appears so. On law, you might be able to make out a point that 319 has been violated. But not who, at whose instance are we going to interfere?
my prayer is
University, why should you?
page 30, my lord. Page 30.
Yes.
Yes. One time.
How many
Sorry,
pages?
Six.
6 more. Okay. We'll come back at 2 o'clock. Okay.
My lord, I want time for filing
Okay, okay, then we grant you time. We'll mark the orders. Heard. 3D Das, Learned Senior Counsel, assisted by Madam, your name?
N. Hondik.
M.
N. Hondik.
N. Hondik.
Yes.
Learned Counsel for the petitioner. We'll stop. Also heard. Mr. Jamo, you're appearing for whom? Higher education.
That is board, my lord.
Three.
Okay.
Respondent number 3.
Also heard Ms. Wangmo, London State Council.
Yes, so here, my lord, I have filed our affidavit, my lord, today, my lord.
Wangmo, 3, Jamo, the London Council for respondent number 4.
No, respondent number 3.
Respondent number 3, full stop. Ms. Wangmo has also informed that the affidavit in opposition has been filed. You have not filed?
Yes, sir. Yes.
3, okay. Your name?
Arriba, my lord.
The R. has entered appearance for the respondent number 4.
Yes,
Full stop. Both Sri Jamo and Sri Reba pray for and are granted 3 weeks' time
Yes.
to file the affidavit in opposition. We give a date so that you can come.
But
Tell us the date of your convenience. After 3 weeks.
sometime
Give a date of your convenience.
last week of February, my lord.
Date of your convenience.
26 or
3 weeks we have said. Today is 12. Not last week. Have it in the first week of March
first week of March,
or 9th of March.
9th of March, for filing of affidavit.
No, yes, for not only for filing, affidavit will be filed before that. 9th of March we can have this matter. This-
All right.
9th?
9th.
my lord. Or then 11th. 11th.
11th.
Okay, 11th, you're okay?
11th.
So that's 11th month.
But I had an interim prayer, my lord. The only thing is that your may pass or not, that is a different.
Interim, what regarding?
That is, if a person, if your lordship is
So what is the
satisfied
interim prayer?
that he should be desist from doing all the official acts till that time. At page 31, my lord.
No, that we cannot.
Page 31.
That perhaps we will not be able to. That we cannot. We can record your prayer and we can pass an observation if you want.
Madam,
We can record your prayer for interim, but we'll negate it.
the only thing is that supposing, I'm not, it's up to your lordship, my lord. If a person, if he is holding unauthorizedly,
No, that
Question
we
is-
can- we can record your submission,
Ma-
but
ma-
we'll reject it. If you want, we can record and reject, or if you want, we
because every day sitting in the office is illegal, if suppose.
then you can record and
Yeah.
you can reject it. Okay.
My lord, my lord.
Okay, Sri Das, the London Senior Council prays for an interim order. Full stop. This court has, however, noted that though this matter had come up on a number of occasions and notice was issued on 13/11/2025, there was no interim order passed. Sarah? This court has also noted that though a writ of quo warranto has been prayed for, the same is at the instance of an university. Full stop. This court exercising equity jurisdiction is also, I cannot be oblivious of the status of the party approaching this court. Full stop. In view of the above, and prior facie, no case for passing an interim order is made out at the behest of an university. In view of the above, the prayer for interim order is rejected. Full stop. It is, however, clarified that the views expressed are tentative in nature and shall not prejudice the rights of the contesting parties for at the time of adjudication of the issue involved.
Deeply obliged.
Item number 12. Lordship, I'm appearing on behalf of Standing Council, APRB, Mr. T. Taba.
Standing Council,
Uh,
Arunachal Pradesh Rural Bank.
yes, APRB.
So what is your instruction?
Lordship, still
filed your affidavit?
no, Your Lordship, we have not filed. We need some time for filing the same, Your Lordship.
But you have not taken steps for service of notice about the respondents.
We have already taken lordship.
When?
In the last occasion, we have already served. Extra copies also already served.
Yes.
You accept for all the
Yes,
respondents, madam?
all the responses.
Yes, Your Lordship.
How many respondents are there?
Uh,
There are two respondents,
respondents.
Your Lordship.
Okay. Do office notes indicate that steps for service of notice upon the respondents have not been taken, comma? Miss, your name?
N. Hondig, Your Lordship.
Anne Hundik, Learned Counsel appearing on instruction of Sri
Titaba, Teto Taba.
T. Tabak, Learned Counsel for the respondents is present.
Yes.
Full stop. Miss Hundik, praise for and is granted 4 weeks time to file the.
Lordship,
affidavit.
fixed date may be given
We'll
in the
give
first
fixed
week.
date. Okay. 4 weeks time to file the affidavit in opposition. Para.
Lordship,
Based on
if possible, it maybe on 3rd of March, Lordship.
3rd of March, is it
Yes.
possible, madam?
This is the second time they have taken time, Lordship.
New matter, 2026 matter.
Yes.
Yes, Your
They are
Lordship.
entitled to take some.
Yes.
Third is your DB day. Can we have it on 9th of March?
9, okay, Lord.
9th March. Okay, you get sufficient time, but ensure
Yes,
that
Your
you file the
Lordship, we'll
affidavit.
file.
Okay, 9 March.
Deeply
Your
obliged.
Lordship.
Item number 13 and 14.
My appeals, madam.
13 and 14, yes, what are these?
My lord.
I
13, this, I am, my lord, 13 of so far 14 is concerned, is already fixed on, my lord, next day this day. My lord, here by this, I am, my lord, I am praying for partial modification of the order passed by this honorable court on, my lord, 5 of this month. The order passed by this honorable court is to restrain me from, my lord, doing any activities up till the, my lord, lane in question. The lane is question is the LPC question. Now, my lord, my situation is that we have already hired the, my lord, machineries, that is the 2 Pogland, by the first, last week of the January. And now we wanted to construct the road, which is, my lord, beyond the disputed area.
When is the next date?
My lord, next date is on 2nd March, my lord.
2nd March.
My lord. So our situation is like, my lord, that the Pogland is, my lord, on the higher basis. Now, the other parties are not allowing us to, my lord, even to construct it, even to carry out the work, which is, my lord, beyond the disputed area, my lord.
We have to balance it.
My lord.
We cannot allow you.
So far, the, my lord, balance is concerned, my lord, we are ready, my lord.
But you are praying for review, Mr. Modi.
No, my lord, partial modification, my lord.
It's not modification, review. We had given a direction after considering the facts and circumstances. If you want a review, file a review. In the guise of an IA, you cannot pray for review. IA can allow only if there is some arithmetical error, some error apparent under face. This is a consideration on facts. You file review. Heard Sri C. Modi, Learned Counsel for the applicant. Also heard Sri Ms. Basar, R. Basar, Learned State Counsel, and Sri.
I am for the respondent number 4.
Name.
Titechi.
Titechi for the respondent number 4. Para. By the instant I, comma, modification has been sought in respect of the order dated 5/2/2026 passed in the writ petition. Para. Aware perusal of the nature of the relief prayed for would show that it is in fact a review which has been sought for qua the order dated 5/2/2026. Full stop. The once there is a requirement to file a review application, comma, the same cannot be done by means of an IA, as filing of a review would require fulfilling of various other formalities and various other requirements. In view of the above, I is dismissed with liberty to the applicant to file review if so advised.
Obliged.
Item number 15 and 16.
15,
Application. Well, 15. Well, 15 is IA. Well,
15 IA is there. Who's for the applicant? Here for the applicant.
yes, I'm for the applicant.
15,
15, I'm for the petitioner. Well,
applicant.
yes.
Applicant, what do you want?
Well, in this case, well, the around 4 villages are coming under project that is called 132 kV transmission project from Namsai to Meo Changlang. So we have filed this writ petition, item number 16, saying that the project which is coming under this 132 kV transmission line, and which is affecting the agricultural land, horticultural land of the petitioners. So if they have said that we don't have problem for coming on the project, but then the affected land owner should be.
In the writ petition, who is appearing for Power Grid Corporation?
My lord, I
Power
appear
Grid
for Power
Corporation.
Grid, my lord. Respondent number 4, I appear for Power Grid, my lord.
Okay, please raise this. Yes, there is an IA file for restraining you.
My lord, they have a similar prayer in the writ petition that also they had delivered, but the court back then had not granted, my lord. We have challenged their maintainability, and
Then you file your objection to this IA, okay?
my lord, we have received IA today itself.
Oh, you filed your objection?
But my lord, I'll just show you the picture.
No, without, if the interim prayer was rejected, was declared.
It was not rejected. I will just take to the order, my lord, of the. We have enclosed in the.
Restraint order without objection, we are not going to have.
My lord, we have an annex in the. I will
My
just take
lord,
to
order
the page
dated
36.
7/5/2025. We have filed our counter affidavit and we say this is forest land, my lord, as per the documents.
In the I, my lord, in the IA also we have annexed the order, my lord. IA page 36. Order is that I will just take to the page 17 of the order.
How it's reasked Mount Learned Council for the applicants who by means of this application has prayed for an interim order of restraint. Full stop. Also heard Ms. R. Basar, Learned State Council. Full stop 3.
N. Khera, my lord.
N. Khera, Learned Council for the respondent number 5.
4, my
5
lord,
is it?
Power Grid Corporation.
4
4.
Power Grid of India.
5, my lord, 5.
Is present, 5 is present online. Full stop para. This court has, however, noticed that while the writ petition was moved on 7/5/2025, an objection was raised on behalf of the respondent number 5, questioning the maintainability of the writ petition. Full stop.
My lord, I am responding
The,
for in
uh,
the writ.
In the writ petition
I am
by the
responding-
by the Power Grid Corporation of India. Though there was an observation that the interim prayer would be considered after, there is also an observation that the interim prayer would be decided after, or would be considered after deciding the issue of maintainability. Full stop para. The corporation has filed the affidavit in opposition in the main writ petition. Full stop para. In view of that, comma, let notice be issued in the present IA. Full stop. Ms. Basar, the Learned State Council accepts notice on behalf of respondent numbers 1, 2, 3, and 4. Whereas Sri N. Khare, Learned Council accepts notice on behalf of the respondent number 5. Full stop. Let file. The Khare, Learned Council prays for some time to file objection.
My lord, page 36, my lord, may I read just last paragraph, my lord?
30.
36 of order. It's a page, order page is 17, my lord.
Page of what?
Of IA 36.
Yes.
IA page 36, may I read just last paragraph, my lord?
Yes.
However, it is made clear that respondent authority as per the Article 300A of the Constitution of India as well as the Electricity Act 2003 and Telegraph Act shall pay the but then, my lord, what is happening is that recently only, I will just show the photograph with the date, page 43. They are now destroying the horticulture and especially if the horticulture district, how they will, if they are supposed to be, if we win the writ petition, if they are supposed to be paid the compensation, how?
You cannot restrain right of way under the Telegraph Act, Mr. Mao.
I'm just seeking.
We'll grant some protection.
Yeah, well, right.
People lost it too. Why your number of respondents have increased in your IA?
Yes, my lord.
Why the number of respondents have increased in the IA? You cannot increase the number of respondents. IA is for interim orders. You had 4 respondents in the writ petition. IA, you have 5 respondents.
No, my lord, I think wrongly it has come, my lord.
It's not wrongly come. You have also included additional deputy commissioner.
My lord, my friend may rectify the IA, and in the meantime, we will seek the.
While at this stage, this court is not inclined to pass an interim order, it is directed that to maintain, it is in the equity, in the balance of equity will be served if it is directed that before the construction activities are carried on, a proper survey of the existing Zirat and the status of the land is done and recorded.
My lord, we are doing everything and everything is recorded.
Yes.
My lord. Yes.
We give a date, Mr. Khera?
My lord. My lord.
List on when, Mr. 2nd of March, is it okay?
Yes.
2nd March.
2nd March?
My lord.
Okay, 2nd March.
My lord, in the meantime, my lord, our construction activities may continue.
We have not said restrain anything.
My lord.
We have not restrained anything.
My lord.
Next.
Item number 17 and 18.
17.
17, we have received a copy of the IA yesterday. We would like to file a reply.
IA for?
Modification of the interim order.
You are the respondent?
Yes.
My lord, here the approach road has been damaged and blocked by the.
Okay, they will get a chance.
Yes, madam. We want to reply on.
You are O Modi.
Yes, madam.
Heard Sri O Modi Learned Council for the applicants who by means of this application has prayed for modification, vacation / alteration of the interim order dated so and so, dated to Koedur. Dated 29/1/2026, passed in WPC 26 AP 2026 para. Repeat of full learned counsel for the opposite party petitioner has, however, prayed for some time to file the objection.
Yes.
Petitioner, anti-petitioner, opposite party, number 1 writ petitioner. Para, how much time?
This matter may be listed on 17, I'll not take much, 17 or 20.
List on, as prayed for, list on 20.
Yes.
20 February 2020.
It's holiday.
Yes.
20 is a holiday.
17, my lord.
17, can you file?
Yes, Monday itself we will file, my lord. It will be Tuesday, 17.
On 18th. 18th, are you there?
Yes.
18th.
18, my lord, would be difficult. 17. 16 would be Monday, my lord.
16, he will not be able to.
Yes.
2 days time will not be able.
16, I would be able to file, my lord.
23rd.
My lord, the problem is that there is one pregnant woman and is growing children without road for more than 3 weeks.
No, understood, but you have to give, today is listed for the first time.
Okay.
You give a date of your convenience, we don't mind. 17th?
17, my lord, but shortest date, I'm giving, my lord. Yes.
17th.
Yes.
Miss R. Basar, London State Council is present.
Oblige now.
Item number 20.
Item 20, who's there? 20. Hearing matter, T soon.
Sorry, my lord, we are waiting in the outside. Item 20.
Right, 20.
Yes.
You are for 20?
Yes.
Okay, for the petitioner?
Yes, for the petitioner.
Okay. And who is for the RGU?
Respondent also present here.
Okay. We can take this matter up for hearing?
Yes. My pleasure, Honor. My lord, my please. My lord, here challenging the one impugned order for promotional post as a assistant registrar from the section officer RGU Rajiv Gandhi University. Here challenging the impugned order.
Just a minute, please. What is your name? Tarum.
GT Tartarum.
And you are, what is
Arnabam.
Arnabab. You appear for the university.
Respondent with 2 and 3. 1, 2, 3. Rajiv Gandhi University.
My lord, here I'm challenging the notification issued by the Rajiv Gandhi University for promoting the post, the promotional post from section officer to the assistant registrar. And in the advertisement notification, there are one clause for sitting a written examination. Written examination. And it was same in violation of notification issued by the UGC. And moreover, the head of the one notification issued by the government of India is strictly prohibiting the institution to not conduct at the verge of retirement. Here, the BC, Rajiv Gandhi University, when he was about to retire, he conducted such advertisement and promotion. In these two grounds, I am challenging this petition. My lord, the petitioner, petitioner is working as a section officer from last 20 years in the Rajiv Gandhi University. And impugned order, impugned notification, I have annexed in page number 12, annexure 1. Here, imposing the unnecessary clause to page 25.
Now, what is the outcome of this? Was the interview done?
The petitioner has got stay interim, and interview has to conduct. Yet we have to conduct the interview. This is pending. Because of this stay, we are difficult to.
Okay, understood.
May I proceed?
Yes, please.
In order to call back the written test examination, which is in violation of the UGC notification, the petitioner submitted a representation before the authority on 26/7/2024, but it was still not disposed of. And my lord, I would like to read the Government of India notification, page number 73. Here, page number 73, notification issued by Ministry of Resource Development, Department of Higher Education, Vigilance Section, notification dated 13/8/2015 to the head of the autonomous body, subject instruction for head, chairman of autonomous body, initiation action to make selection at least 2 months before conducting their tenure. Sir, I am directed to bring to your notice the general convention in government that head or select chairman of various organizations do not conduct selection few months before they conclude their term in the office. The competent authority has directed that the competent authority has directed that the head select chairman of the organization under the control of the department should refrain from initiating any action to make selection at least 2 months before the expiry of their term of the retirement. In this regard, I would like to say, my lord, BC, former BC, was joined in the Rajiv Gandhi University on 4/10/2018 for a 5 years term. And his term, 1 year's term was extended till 3/10/2023.
5 years term started when?
4/10/2018, 5 years.
4/10.
2018, 4/10/2018. And beside that, one year has been added beside the 5 years term. And it was till 3/10/2023. 1 year, if we added 1 year more term beside the 5 year term.
3/10.
3/10/2024.
2024.
Yeah, yes.
Okay.
And impugn notification was yes, in the August.
Yes.
So that is one ground for challenging this writ petition, because their retirement was only lapsed 15 days, and that impugn notification was sought for conduct the test.
Yes.
And another notification issued by the UGC to the entire 45 universities to frame model cadre recruitment rule of their page number 89.
Yes.
89 and moreover, notification UGC page number 73, Government of India notification, page 89.
Yes.
My lord, page number 92.
Yes.
Here on another direction from the UGC.
Now, how is 89 relevant to your case?
Here, page number 89. Here, authority issued a notification to the UGC, this authority, the UGC issued notification to the university to frame CRR, that is cadre recruitment rule
Where?
of their
Page 89, where is it?
revision guideline program. So I'm directed to here with the. May I read? I'm directed to enclose here with a copy of the OM number so and so, issued by the Government of India Ministry of Personnel, PG and the Pension Department of Personnel Training, New Delhi, on subject mentioned above, and to request you to follow the above guidelines instructed for various post while framing amendment of requirement rule. It is also informed that the interview clause should not be added by university in its own level if it is not prescribed by the DOPT in the model requirement rule. This is a part of that direction, and another direction is issued in by the UGC. That is page number 92. In that notification, the university submitted numbers of representation before the UGC for correcting their CRR. And in that response, the UGC write a UGC page number, my lord, kindly peruse the page number 892, annexure 13.
Yes.
Here, subject ordinance of Rajiv Gandhi University. It's indicated the university submitted the numbers of ordinance before the UGC for consent, for grant of permission. And particular relevant in my case, here, page number 96, in the same notification, same order, here, deputy registrar and the assistant registrar. This assistant registrar is relevant, particularly this clause is relevant to in my case.
Yes.
5, clause 5.
Yes.
Assistant registrar. Similarly, for the post of assistant registrar, the higher grade pay of rupees so and so under CAS has also been provided, which is not permissible as per rule of UGC Government of India rules. The above are example only. University has made a lot of irregularity in each of the posts while making the recruitment rules. The university has also not made the preamble for recruitment rules as per requirement of DOPT norm. Being serious irregularity made in the recruitment rules, it would be more appropriate that the university may be advised to immediately withdraw the recruitment rules and keep in abeyance any requirement and promotion on the basis of the requirement rule. If the university had made any promotion under the provision of this requirement rules in violation of the Government of India rules, it may be withdrawn immediately. After issuing this notification, the UGC issued another notification, that is next page, page number 97, annexure 14. Here, subject to the register.
What prejudice do you suffer, Mr. Toro?
My lord, here we are 7-8 members.
No, you said that you are working for 20 years as section officer.
Yes.
You become eligible to be promoted to the post of
Assistant
registrar.
Yes.
Now, a recruitment test is being conducted.
Yes.
A recruitment process. How are you prejudiced if the process is conducted by an outgoing VC? There may be aberration in the rules, but what prejudice would be caused to you?
My lord,
You are an internal candidate.
my grievances in this advertisement that there are 7 or 8 members who qualify for the same post. But here, seniority is not given priority. Seniority, I have been serving as a 20 years in this section officer, and another cadre also.
That will come at a later stage. But how do you stop the advertisement? Advertisement does not say anything about seniority.
My lord, if
Nabam, there is a restraint order passed by this court. So as on today, nothing has progressed. Now, this post of assistant registrar cannot be allowed to remain vacant. For the last more than a year, it is lying vacant. And this advertisement was of August 2024. So if that first ground that the VC was retiring, that is gone now.
Yes.
Now you can go for a fresh advertisement. Where you consider the case of the petitioner, why should the entire process be?
Yes.
Lordship, I'll come to just, I may just crush the case.
So, my lord, another my submission, my ground of
Yes, Mr. Nawam,
argument is that
let him complete, then we'll come to you.
the UGC repeatedly sent the letter or direction to the university to frame requirement rule, but without having any concrete requirement rule, they issued advertisement and unnecessary imposing restriction, because if I'm seniority and I'm serving as a section officer for last 20 years and this qualification only 5 years, and another my junior, if they come, if they hold the post of that promotional post beside my seniority, if seniority is not given priority, then what is the purpose of my seniority? Because it's a promotional post. That written test should not be there, only based on their seniority, because direct requirement is different thing. This is a promotional post. The promotional post seniority must be given seniority.
Promotional post, where do you get?
My lord, here.
Where do you get it's a promotional post?
Advertisement itself. My learned friend who represent the university will give answer, because this is a completely promotional post. My lord, let me submit one more document. Here, page number 16, page number 100, annexure 16. Here, university write a letter. This is confirming that university has no requirement rule. To Mr. So-and-so, Under Secretary UGC, New Delhi, modalities for implementation of the models here regarding letter number so-and-so. Here, with reference to the letter A cited above, I am furnishing here with the requested information in the prescribed format in respect of Rajiv Gandhi University or so on. Yes.
Even in a promotional post, it may not be on the basis of seniority. It can be on the basis of merit.
Yes, merit, of course, merit is there.
What are the rules? Please show us the rules. Under what rule this promotion, this post of assistant registrar is going to be filled up?
Yes, here, my lord, I have annexed the similar nature that university, deemed university, nearest, and the other university.
Mr. Abam, what rules do you follow for filling up?
Lordship, in this case, the RGU has 5 sanction posts of assistant registrar, 5 sanction posts. Lordship. Just come to the crux.
Yes.
RGU has 5 sanction posts of assistant registrar. And as per recruitment rule, 50% direct recruitment and 50% by promotion.
Yes.
RGU has earmarked 5 positions of assistant registrar, Lordship.
Yes.
Then out of 5, 2 direct recruitment filled already through direct recruitment. Position is like, and 2 direct recruitment already filled, and 3 promotion. And out of 3 promotion quota, 1 was vacant due to superannuation of one Sri Tekendra Nath, assistant registrar who is already retired. So for that vacant post only we have advertised. And subsequently notification was made to fill the vacant post of the assistant registrar under promotion quota, Lordship. Promotion quota. Promotion quota through selection method. Through selection method is mentioned in the model cadre recruitment rule by the UGC 2022. So, Lordship, we university have no any cadre recruitment on rule. And that was way back 2015, but that was rejected by 2017 by the UGC. So now we are compelled to adopt the model cadre recruitment rule by the UGC.
Where is the model?
Lordship, here. Lordship, in my affidavit page, yes, affidavit of opposition, page number 119, annexure 15. Page 99, either 119 in my affidavit. Here, this is the letter, Lordship. Affidavit of opposition. This is the letter.
Page 119.
Page 119. Either 99, just there. 119. 119. Affidavit. Lordship, here, one letter that is issued by the Union Grant Commission on the 27 September 2022. Affidavit in opposition.
119. 27 September.
27 September.
Yes.
Lordship, here, this is the letter that issued by UGC addressed to the registrar all central university of the country. Subject model cadre recruitment rule for central universities, only for central university, Lordship. So our is central university. As you are aware of, UGC is continuously pursuing with all central universities for filling up of all vacancy posts and to conduct recruitment of faculty and non-teaching position on the mission mode, Lordship, mission mode. In view of the difficulty faced by some central universities for finalization of their cadre recruitment rule, CRR sort, of the non-teaching employee, Ministry of Education requested UGC by letter number so-and-so dated 10th March 2022 to constitute a committee for formation of model cadre recruitment rule for non-teaching employee. Accordingly, UGC constituted an expert committee, Lordship, expert committee.
Yes.
For the purpose and based on the committee recommendation.
Okay, this model CRR was framed or not? Framed.
Framed.
When?
Now, this is framed by, we are adopting, I'll come to the
We
point.
come to that point
Uh,
directly. This
The
is
Middle Code Recruitment Rule as approved by the.
not required to
Okay,
come
Lord.
to the cadre, recruitment rules.
Then this recruitment rules, this is the recruitment rules here. So.
How do you fill up the post of assistant registrar by promotion? What is the procedure?
Procedure is, yeah, that's already have submitted, 50% by direct.
No, that is the quota. How do you, what is the procedure you adopt for making the promotion?
Through written test, through merit completeness.
Merit, let us see.
Among the Pidar, there is 7 at a stage.
Let us see that criteria.
We'll come to the point. Lord. In my affidavit. The procedures for adopting that is, I'll come to just, I'll try to clarify it.
Have you annexed that model rules with your affidavit?
Model rules, front page, the order from the UGC, that's I've annexed that. But entire model federal recruitment rule is here itself. It is here inside. And for assistant registrar for only, that is.
For assistant registrar, have you annexed? Yes. Page
Number. Selection or non-selection post. That is selection, average of selection. So Lordship, here method of recruitment, whether by direct recruitment or by promotion, or by deputation, observation, and percentage of posts to be filled by various methods. That is 50% by direct recruitment and 50% by promotion, filling by deputation, direct recruitment. This. So here our that is selection method. That is whether selection or non-selection post. So our the selection post. Selection post.
From where do you get? Where is it?
This is here, but
Have you annexed in the affidavit?
This portion I have not annexed, and he has annexed in his petition.
In my petition. This is,
Yes,
yes, this is
in his petition.
Model Recruitment Local Cadre Rule 2015 and page number 59. This is from.
This is 2022 cadre recruitment.
That 59.
Yes, page number 54 is my annexure and relevant portion is 59.
Okay.
Because this annexure 5 is for promotional post assistant register.
Yes.
Particularly page 59, mode of promotion zone of consideration and benchmark. Here, mode of promotion to the post in university shall be seniority come fitness with good ACR. Must have served a section officer on a regular basis for last at least 6 years. Only these two conditions. That is a promotional post eligibility criteria.
From where do you say that it is for the post of assistant registrar?
My lord, page number 54, 55, here heading itself. On the term and condition on service and requirement rule for the post of assistant registrar.
55.
This is the existing rule of the university. Now my learned friend. Yes. And these rules were approved in the Executive Council.
Mr. Nabam, if the criteria is seniority come fitness.
Yes.
then the scope of holding a written test will not come.
Lordship, I'll come to the, just one judgment is also, latest judgment, Jammu and Kashmir, that's the Central University, Jammu and Kashmir
Please
judgment.
show it to us.
Lordship, this is what the petitioner claiming, this is 2015, that is recruitment rule. That was rejected during 2017 by the UGC. So we are not adopting that old rule. We are adopting the new rule of 22, adopting.
And even that,
Under mission mode.
that 2020 rules is also not accepted by the authority. If I allow, I will show the document.
Okay, let him go.
Yes.
So judgment also.
That judgment is for the university, those who have own requirement rule. Now we have no such requirement rule. It is not applicable in this case.
We cannot adopt the old rule. We are directed to adopt the new medal cadre recruitment rule of 2022, Lordship. So we are adopting that. Now,
Let us see that.
Lordship, I'll have to where I let go. So the petitioner is praying for to consider his case under 2015 cadre recruitment of our university. That was already rejected. 2017. We cannot adopt that at all. So now here, Lordship, in this case, Sanjeev Gupta versus Central University of Jammu and Kashmir. This was on 5th May 2025. Here, Lordship, in second para, it is pertinent to mention here that impugn notification dated 3/8/2023 was issued in suppression of the earlier notification dated 12/7/2019, issued by the respondent university for the same post, whereas the impugn notification dated 3/12/24 has been issued in suppression of all the previous notification. Both the impugn notification have been issued in according with the cadre recruitment rule of 2022. So we are adopting the 2020. We are compelled. We cannot use our own cadre, which has already rejected. UG has rejected 2017. Lordship, here in his petition already in my affidavit. We had our own cadre recruitment rule, but that was, my lord, a page number 180 on a ordinance, our ordinance. My affidavit, Lordship. (181) of my affidavit. Here, page number, Lordship, page number 185 of my affidavit. Yet in the last para for assistant registrar post, this was already rejected by the recruitment cadre recruitment rule, which was prepared 2015 by own university. That was rejected. Here, petitioner has himself annexed the document here, the rejection document by the UGC. So now we are compelled to adopt the UGC model cadre recruitment 2022 only. We cannot go beyond that now because it will be without jurisdiction, without authoritative law.
What does the model rules prescribe for the purpose of promotion to the post of assistant registrar?
That is 50% by direct recruitment.
No, we are not. That is only a division of post. 50 by direct, 50 by promotion. How do you do the promotion?
Merit completeness through written test. That is within the PIDR, who qualify. There is at present there is 7 PIDR candidate. Within them only skill test will be there. Nothing more than that. We are not inviting the outside of the people to participate in that exam. Within the cadre, within the PIDR employee, 7, there is total 7. And during the Lordship, it's very sad to inform that during the process of this, one person has already expired. Otherwise, if this case was not there, he could participate, he could throw the exam, he could be the assistant registrar. But unfortunately, and moreover, in my affidavit, just I will clarify how.
See, without wasting much time, you had contended by submitting the earlier rules that
Yes.
it is to be, promotion has to be done on the basis of seniority.
Yeah.
Senior.
Now, Mr. Nawab has said that those rules of 2015 has been rejected by the
Rejected.
UGC,
UGC.
and for which a model rules, recruitment rules are presently followed. The model rules in a very clear term says that so far as promotion aspect to the post of AR is concerned, it has to be done on the basis of merit from eligible candidates.
Lordship.
So how do you assess the merit?
My
To
lord,
have a qualifying test, written test, you cannot say that this is something unreasonable.
my lord,
Had it been a seniority, then you have a case that you cannot introduce an examination. I am senior, but here you cannot stop it.
my lord, regarding that queries, here my learned friend submitted model CRR that has been adopted by university. It is not enforceable. The document says, my learned friend what submitted, it's not enforceable. Here, kindly, I may be allowed to submit one document, that page number 100, just my petition, read petition. Annexure 16, page number 100. Whether university has framed the CRR of non-teaching staff, yes, no, answer is no. That means till 29 September 2022, the Rajiv Gandhi University has not submitted, not prepared any CRR of non-teaching staff. Here is the Rajiv Gandhi letter itself says, till 29 September 2022, they have not framed any rules for non-teaching post. And here,
No, it is correct. They have not framed.
and
They are
moreover,
Don't have our own.
yes,
they are following the model rules.
that is there. Model rule is not enforceable. Here, page number 102, Annexure 18. The university has sent one representation before the UGC
Yes.
for confirmation of model CRR. Here, requirement rule report, here already report submitted by one learned Solong Sonam, is a representative of Rajiv Gandhi University who visit to the UGC and here write the report. Here, on 27 January, working day after the Republic Day, I visited the office of the Under Secretary, Central University Ministry of Education of so and so. Here, clause 1, the Under Secretary has specifically mentioned that model CRR is sent by the MOE is not enforceable and is just a model, repeat model, which is a reference for all those universities which have not yet drafted and any approved RR. This CRR is not a enforceable, my lord. Is only for model to frame on RR. It cannot be enforceable.
No.
This CRR is only for guideline, for framing on requirement rule. It cannot be enforceable. They repeatedly said it is not enforceable, only model.
Which here, Lordship, here sentence which have not drafted any approved RR.
Yes.
So we don't have approved RR. So we have to adopt that only.
It's
Our
not
cen-
enforceable, my lord.
Our university.
My learned friend failed to understand, not enforceable. This CRR is not enforceable. Not enforceable. So therefore, without having any such rules, how the university can impose such unnecessary restriction imposition upon the cadres who qualified for the promotional post. This is not the direct requirement. It's only promotional post. And I have shown before this honorable court requirement rule 215. It is approved by the executive council. And my learned friend submitting, they are adopting. It cannot be adopted, but it adopted only for framing, only guideline, but it cannot be enforceable. And my learned friend said 2017, 2015 rule has been rejected. Where is the document? There is no such document showing that the existing university requirement rule has been rejected by the UGC. No such document is there.
It is there. You have annexed in page 85, 185, Lordship.
Uh-huh.
Page 185.
One-
This was the ordinance page in my affidavit. In my affidavit, Lordship, I'll come. In my affidavit, in opposition, page number 181, Lordship. Affidavit in opposition, page 181.
This is
Let me complete.
this is observation.
This is the ordinance. Ordinance of Rajiv Gandhi University regarding Lordship here. Page number 181, Annexure B, dated November 2007. This was the letter from the Undersecretary, Government of India, New Delhi, the Ministry of Human Resource Development, Government of India. So here, I am directed to refer to your letter number so and so, dated 2017, on the subject mentioned above, and to inform you that matter has been examined and comment of the UGC on the ordinance of the Rajiv Gandhi University are given below. Like Lordship here, UGC comment is here, and title of the ordinance is here. And now regarding page number, come to the page number 185, Lordship.
Page?
Page 185. Page 185.
Yes.
For more particular, for assistant registrar post. Similarly, for the post of assistant registrar, the higher grade of pay of rupees so and so under career advance scheme has also been provided, which is not permissible as per rule of UGC, Government of India. The above are example only. University has made a lot of irregularities in each of the posts while making the recruitment rules. The university has also not met the preamble of the recruitment rules as per requirements of the DOPT norms. Being serious irregularities made in the recruitment rules, it would be more appropriate that university may be advised to immediately withdraw the recruitment rule and kept in abeyance any recruitment and promotion on the basis of this recruitment rule. That means 2015, which was our own recruitment rule. If the university has made any promotion under the provision of this recruitment rule in violation of the Government of India rules, it may be withdrawn immediately. So the petitioner is claiming 2015. Now we are claiming that a university, the respondent is claiming that we are not adopting the 2015. So we are adopting the model cadre recruitment rule issued by the UGC. We are compelled to those central university who don't have own recruitment rule, which is approved by the UGC. That means we have to adopt the central. That means the model cadre recruitment rule issued by the UGC. This is the basic the crux of the yes. And moreover, here Lordship, we are not curtailing his fundamental rights. He is also allowed to participate. You just selection. This is selection merit cum fitness. In merit cum fitness, there is the method is through written test, little written test, and fitness will be there. And otherwise, if we directly by violating the model cadre recruitment of 2022 and adopting this old rule 2015, again there is issue. We cannot adopt the 2015. And moreover, if we allow him also in the seniority list, if we consider also, he is serial number 2, not in 1. And 1 is not claiming the post. Serial number 1 seniority list also, 1 is not claiming. There is seven this Peter candidate within from the section officer, from the senior personal assistant. They are promoted to assistant registrar post by seeing the experience, skillness, and Lordship and other the performance, excellency. Because now the world is seeking excellency. One of the central university, lone universities and central university, we need a person who is skilled in writing, drafting, and all correspondence. Because assistant registrar has to appear before a UGC when the meeting is conducted. He has to present in a written he must be expert in computer also. So written is very necessary in this case. So that's why we have adopted the UGC this method, and the written test is there. Written test there. So there is no any violation of Article 14 at all. And my lord, here one in the case of this State of Himachal Pradesh and other versus Rajkumar, here also this here employee has no vested right to be considered for promotion according with the repeated repeal rule. Repeal rule. Lordship may kindly. This is the judgment, the Supreme Court, Honorable Supreme Court judgment 2023, 773, Lordship here. Yeah, Lordship, in front, that's operative person. Employee has no vested right to be considered for promotion in according with repeal rule in view of the policy decision of the government. Moreover, no obligation. Lordship, here in the front page, that is.
No, that is the headline.
Headline.
Paragraph.
They are inside. In my affidavit, Lordship, may.
No, in this decision.
Yes, decision.
Which paragraph are you referring to?
Referring page.
You cannot refer to a head note. Head note is not the.
Page I have not. Lordship, judgment copy is annexed here in my affidavit. From page number 120 of affidavit, Lordship. Page number 120. Regarding the service matter, the Honorable Supreme Court has made a landmark judgment in this case. So here, the employer has no vested right to be considered for promotion in according with the rule repeal in view of the policy decision of the government. Moreover, no obligation on government to make appointment as per all rules in event of restructuring of the cadre intended for efficient working of the unit, which however must be justified on touchstone of Article 14 of the Constitution, Lordship. So here in this case, what happened, Lordship? We are not depriving him. He is also allowed to participate the just written test only. So only there is one vacant post is there. For that only merit cum fitness method has been adopted, and that is the guidelines of the model cadre recruitment rule of the 2022, which is issued by government of India through UGC laws. And other university like Lordship here in.
Mr. Torum.
Yes.
See, it's a post of assistant registrar. It cannot be solely on the basis of seniority. The basic jurisprudence of service, basic principles of service jurisprudence is that in cases of promotion in lower rank of the ladder, seniority can be the basis. But if you go up, it is merit.
Merit.
And here is the post of assistant registrar. It cannot be on the basis of seniority. It could have, if the earlier rules were existing. Earlier rules, the UGC has criticized, has said that you cannot go ahead. You may have a case that they have not framed new rules, and there is a notification, there is a communication that the model rules are not enforceable.
Yes.
But they have to follow the principles of the model rules, which says that this post of assistant registrar has to be filled up on the basis of merit and fitness. Now, how do you assess merit? It can be done through a test.
My lord, here one notification issued by the UGC here clearly restricted the university not to conduct non-teaching post unless RR rule is made.
Non-teaching post does not include a post of assistant registrar in the higher cadre.
Yeah,
my lord, here non-teaching post here clearly means on.
If you once you say non-teaching post, it would mean normally the grade 4 post. There are posts of cleaners, multitasking, all those.
My lord, in that case,
where
I agree with.
Have any much role here for assistant registrar. Your merit has to be. You need to have minimum merit.
My lord, my question here, of course, the principle is there, but university has no such rules. That without such rules, without requirement rules, how university can conduct such a interview.
Then you would say that no recruitment should be held.
No,
Only
that can be held
Suppose-
only at the advice of the UGC.
No,
So-
let us be alive to the practical situation.
Yes.
The RGU had a set of rules, 2015. There is a notification, there is the communication of 2017, whereby these rules have been criticized and said that it's not going to work out. Now, there is a set of model rules based upon which all the universities are required to frame their own rules. Now, RGU has not framed their rules.
Yes.
But at the same time, recruitment is necessary. So what under those circumstances, what do you do?
A university must write a letter to the UGC in the institution and take permission. Because they are already restricted the one
Lordship, there
by
is letter,
issuing notice.
permission is there. Permission is there. This is the
That is
page
not
number 192, Lordship. This is the letter issued from the Director Central University, Department of Higher Education, Government of India. Page number 192, my affidavit. This is the permission letter issued to the registrar, the Vice Chancellor. To the Vice Chancellor of Rajiv Gandhi University, Malad Annexure D, page 192. The request of the Vice Chancellor of Rajiv Gandhi University for clarification on the mission model recruitment for filling up a vacancy in the university regarding. Sir, I am directed to refer to your letter because we seek a direction. So refer to your letter dated 4/9/2023. BC has sent a letter to 23 on the subject mentioned above and to say that competent authority has allowed the Vice Chancellor of the Rajiv Gandhi University to issue notification vacancy in both teaching and non-teaching post, conduct screening process and issue appointment order during the period he is continuing in the office of the Vice Chancellor by order dated 3/10/23 issued by Ministry using power conferred in first proviso to status of 22/4 of Rajiv Gandhi University Act 2006. Lordship. So this was the authority authorized to the BC to.
We will decide this.
No, my lord, this is for
And
another
more-
connection.
Huh?
Let me submit. Because this requirement, this authority, this letter is issued against the former BC. Well, he was extended for another 1 year period. Only that regard this letter issued.
Yes.
But this letter is not for conducting the requirement in absence of requirement rule, in absence of RR. That is not that. This is different thing.
But how do you make a recruitment? Will you letter post remain vacant?
My lord, my humble submission.
You're
My
trying to stall the process.
my humble
You're
submission.
trying to stall the process only because you are senior in the SO. You're trying to stall the process.
No, my lord,
We
I'm not.
don't allow. We may impose cost upon you. We may impose heavy cost upon you.
No, my lord, it
Please
will
write.
hurt. It will hurt to the petitioner. I'm not claiming because I'm not in the number one seniority. I'm just maintain the procedure.
This
Seniority.
is being maintained for a post of AR. There has to be a selection, and in a selection, your merit has to be assessed. For assessing the merits, they have introduced written test, and you are trying to solve the process.
My lord, that has to be approved by the UGC because that requirement rule is not approved by the UGC. Without having a UGC, how the university can conduct such a advertisement? My lord, that is.
Please write.
And lots of this notification of advertisement by Executive Council, past Executive Council, 40th Executive Council of the university. Thereafter, the recruitment process was started. Page 187, Executive Council meeting.
Please have your seat. The present application under Article 226 of the Constitution of India has been filed in connection with an advertisement published on 28/8/2024 by the respondent number 3 for filling up, amongst others, the post of assistant registrar in the university. Full stop. Para. Please have your seat. As per the facts projected, the petitioner is working for the last more than 20 years as a section officer in the university. Full stop. As per the earlier recruitment rules, as per the procedure, as per the existing procedure, the post of assistant registrar are to be filled up both by direct recruitment and by promotion in the 50-50 ratio. Full stop. As per the earlier rules of the university, the post, the promotional post has to be filled up on the basis of what? Seniority. Seniority or what? Where is the earlier rules? Earlier rules of 2015, huh?
Yes, sir.
The post of the post of assistant registrar by way of promotion was to be filled up by seniority. Full stop. However, in the impugned notification /advertisement dated 28/8/2024, there is a prescription of written test, which, according to the petitioner, is not in accordance with the rules. Full stop. It is also contended that no new recruitment rules having been framed, the draft, the model rules of 2022 could not have been taken into consideration without a proper permission from the UGC. Full stop. I have heard Sri T. Tarum, learned counsel for the petitioner. I have also heard Sri R. Nabam, learned counsel for the respondents. Sri Tarum, the learned counsel, has submitted that a communication was issued by the Ministry of Human Resource, Government of India, dated 13/8/2015, as per which, no selection process was to be initiated within a period of 2 months from the date of retirement of the heads / chairman of the organization. He has submitted that the VC who was holding, that the existing VC was appointed on 4/10/2018 for a period of 5 years, and 1 year was extended. Full stop. Within after the extended term, after the extended period, his term would have expired on 3/10/2024. Full stop. Therefore, the advertisement dated 28/8/2024, which has been issued within issued before within 2 months from the date of such expiry of term is in conflict with the aforesaid guideline. Full stop. The Learned Counsel has also drawn the attention of this court that the UGC had directed via the communication dated 14/8/2015 to frame recruitment rules, wherein the aspect of interview should not be added. Full stop. He has also submitted that in a communication of November 2017, it has been clarified that for the promotional segment of the post of assistant registrar, it was the such promotion has to be made on the basis of seniority, and written test cannot be held. Full stop. The Learned Council has submitted that in this case there is an interim order which is operating, and therefore the petition may be directed to be petition may be allowed with a direction to carry out the selection process on the basis of seniority and seniority.
Seniority cum fitness.
Seniority cum fitness.
As per 2015 rules, seniority cum fitness.
As prescribed in the rules of 2015. Per contra, Sri Nabam, the Learned Council for the University, has submitted that the projection made is incorrect both on facts and law. Full stop. He has informed that the university has 5 numbers of sanctioned posts of assistant registrar, and by going by the ratio of 50-50 for direct recruitments and promotion, 2 persons have already been appointed on direct recruitment basis. Full stop. Out of the 3
promotion
on promotional quota, 1 had fallen vacant, for which the advertisement was issued on 28/8/2024. Full stop. By drawing the attention of this court to the affidavit in opposition, the Learned Council for the University has referred to a communication dated 27/9/2022 issued by the UGC to all the registrars of central universities on the aspect of formation of a model code of recruitment rules.
Model cadre.
Model cadre recruitment rules. Full stop. He has also submitted that so far as the rules of 2015 are concerned, those were rejected by the UGC, and in this connection, he has drawn the attention of this court to the communication dated November 2017, whereby the UGC had written to the ministry, whereby remitted for withdrawal of the earlier recruitment rules. Full stop. The Learned Council has also submitted that the aspect of going ahead with the recruitment process was permitted by the competent authority via notification dated
3/11/23.
3/11/20. No, don't say notification. By communication dated 3/11/2023, whereby the existing VC was accorded permission for going ahead with the same. Full stop. He has also relied upon the decision of the Jammu and Kashmir High Court dated 5/5/2025, rendered in so within bracket Sandeep Gupta versus Central University of Jammu, in which it has been laid down that for the post of assistant registrar, the selection can be done through written test. Full stop. Reliance has also been placed on the case of the Honorable Supreme Court, reported in 2023, 3 SCC 773, bracket State of Himachal Pradesh versus so and so, wherein it has been laid down that an employee has no vested right to be promoted on the basis of repealed rules. Full stop. In his rejoinder, Sri Torum, the Learned Council, has submitted that there is a direction of the UGC that without framing that the model cadre recruitment rules are not enforceable, and without framing the recruitment rules, such no recruitment can be made. Full stop. He has emphasized that the rules of 2015 as such were not repealed. Full stop. He has also submitted that the communication dated 3/11/2023 giving permission to go ahead with the recruitment is not touching on the aspect of the aspect of non-availability of recruitment rules of the university.
It's only expect for Age Part Act, University Act for extension of time only, BC time.
Yes. The rival contentions have been duly considered, and the materials placed before this court have been carefully examined. The challenge is with the advertisement dated 28/8/2024 for filling up, amongst others, the post of assistant registrar. Admittedly, the petitioner is a section officer, which is the feeder cadre for filling up of 50% of the cadre strength of assistant registrar as per the rules holding the field. Full stop. The issue which arises is the process of filling up of the said post of assistant registrar through promotion vis-a-vis the rules holding the field. Full stop. It appears that the respondent university had a recruitment rule, had a set of recruitment rules of 2015, as per which the said post by promotion was to be filled up on the basis of seniority cum fitness. Full stop. The said recruitment rules were, however, considered by the UGC, and while the communications dated November, where is it?
Yes,
By the communication, is it November? November 2017, a direction was given for withdrawal of the said recruitment rules. Full stop. This court is also apprised that a model cadre recruitment rules have been formulated based upon which each of the universities are required to frame their own recruitment rules. Full stop. Though the learned counsel for the petitioner may be correct in contending that there are communications to show that the model cadre recruitment rules are not enforceable, in absence of the rules being formulated by the respondent university, it is the spirit and principle of the model cadre recruitment rules which are required to be followed. Full stop. The model rules prescribes that the post of assistant registrar is to be filled up on the basis of merit cum fitness. Full stop. It is also a settled principle of service jurisprudence that as the post that in the promotional ladder, while the post at the beginning of the ladder can be filled up on the basis of seniority, the posts which are at the top of the ladder are to be filled up by merit, as merit would as those posts would require specialized skills. Full stop. It is not in dispute that the post of assistant registrar is a superior post. Full stop. The learned counsel, so far as the argument of the learned counsel for the petitioner regarding that uh, or we'll add something here. As regards the aspect, as regards the submission made that the notification for IMP notification was issued within a period of less than 2 months from the date of remission or office of expiry of the term of the then VC, this court has noted that the competent authority wide the communication dated 3/11/2023 had accorded permission for going ahead with the recruitment process. Full stop. Para. In view of the aforesaid facts and circumstances and the discussions made above, this court is of the opinion that no case for interference is made out. Full stop. The petition is accordingly dismissed and the interim order is vacated. Full stop. The university, since the post in question is lying vacant in terms of the interim order passed in this court, which has been vacated today, the university would take expeditious steps for completing the recruitment process, in which the petitioner who is eligible would be treated at par along with other similarly situated persons.
Lordship.
Highly obliged.